In your package, there was a memo, and then on the backup, you have the sheets there. I will let you know in the highlights, the charter counties that do not follow state statute for setting salaries, they're in the blue. And then that data we obtained by actually calling the counties and confirming. So that's your information in there. I apologize, I neglected. You also asked the last time the county commissioners received a raise under the charter. We could not find at this point where they have received a raise. We recall they did vote for a raise and then shortly rescinded it. But that would have been a number of years ago. But they're at the same salary as they were when the charter began.
Are there any questions?
Mr. Chairman,
Ms. Smith?
I was the one that had asked for that information, and I really want to say thank you to the staff, because I guess I figured that the Florida Association of County Commissioners would just have that right at their fingertips, and that was not the case, and they spent a lot of time gathering the information, and I want to thank them very much. And it was 1994 since the county commissioners have had any increase, and I will be bringing something back to this board maybe the next meeting.
Okay, thank you very much.
Okay. And excuse me, Mr. Chair, we have one more report we put in.
Second, number B. Go ahead, Jim.
Yeah, thank you very much. The three-person review panel selection, we put it out for procurement, and the selection committee met last week. They recommended awarding to the three firms, which is Nablers, Gibling, and Nickerson, Gray Robinson, and Civ Forge Law. That the protest period concludes on Friday at 5 p.m., and then after that we will begin negotiations with them, and those will be your three panel attorneys, one from each of the firms.
Thank you so much. Other questions? Did you hear that question? How much was the last panel paid?
I apologize. Should have that in front of me. I'll get you the information.
All right. Other questions on those two items? All right. With that said, we are going to move to our proposals. We have hearing number 2 on the charter cap.
Mr. Chair, there's reports of on the agenda number 2 of the Commission Attorney. If you're going in order, E, number E2, CRC Attorney.
Is your mic on?
Is your mic on?
Oh.
Okay. Want to go ahead?
Yes. I'll be brief. The opinion is lengthy, and I'll be happy to answer any questions on it. I will tell you, just to update a little bit, one of the questions that we could not come to a complete answer on, and that is in the event of a recall election, who pays for the recall? Well, the statute is very clear that the petitioners that are seeking the recall pay for the petition review, but then when it's actually placed on the ballot, the statute is silent in that regard. I did contact the supervisor of elections. She in turn contacted the county attorney's office, and the county attorney's office has reported back as of a couple of days ago that they could not find anything in the statutes that talked about who has the responsibility for paying for that. My guess, relying on 40 years of local government experience, is that more likely than not, the jurisdiction that has the person that's being recalled is probably going to end up paying for that. What authority that I have for that? Nothing. I have no authority for that, but I would suspect that that's how it would be handled. The supervisor of elections, by the way, didn't know the answer to it because since she has served as our supervisor of elections, we've had no recall elections in Brevard County, which is probably says something for the stability of our government. Another point, Mr. Moore had asked for an opinion regarding whether or not the CRC's recommendations can be changed by the county commission once the proposals have been passed on. That is still under review at this point, and an opinion will be forthcoming. and I'll be happy to answer any questions.
Thank you, Mr. Gogelman. Are there questions? Mr. White for a question.
Yes, I'm just wondering, when you say the jurisdiction, does that mean that for a school board recall, that the school board would pay for it?
I would think.
Okay.
Yeah.
As opposed to just the supervisor?
I would think.
Ms. Trittis, her question.
Not a question. Well, I'll get to a question, but I want to point out something about, are you in the memorandum, your entire memorandum now?
Sure.
Okay. In the memorandum, Attorney Googleman makes the opinion that it's a close call on the recall of school board members, but he is of the opinion that it's not consistent with general law. And I wanted to point out a couple of things about Attorney Googleman's opinion. First of all, thankfully, he does cite some charter provisions in other counties about recalling other constitutional officers, and those counties do provide for the recall of constitutional officers such as sheriff, property appraiser, tax collector. I wanted to point out that what's not included in the memo is that there is 2 counties that specifically provide in their charter for the recall of school board members, and that is in the city of Jacksonville, which is the same as the Duval County. In their charter at 15.01, it says any officer elected in any consolidated government or school board election may be removed from office in the following manner. So that charter specifically provides for the recall of school board members. And then in Sarasota County, in section 6.3 recall, the procedures for the recall of a county commissioner shall be as set forth in general law. The procedures for the recall of other elected county officers, including but not limited to the sheriff, supervisor of elections, tax collector, property appraiser, and clerk of the circuit court, shall be the same as those for the recall of the county commissioner, end quote. So that but not limited to would also include school board members. So I wanted to point out that there are, in other county charters, the recall of school board members is specifically provided for. Also wanted to point out that Attorney Googleman makes a lot to do with a 1971 Attorney General opinion that has some really broad language about county charters not really having much authority in the matter of school board operations. But if you look at that decision, you know, what the Attorney General opined on was really internal administration of the school board, such as may the charter provide for the purchasing material, supplies, and equipment required for operation of the school system through a Department of Central Purchasing established under the county charter, and can people basically be hired through the county-wide hiring system. So those were the specific questions that were asked, and I don't agree with the general language in there that it applies to recall of school board members. And also, that was in 1971, but in 1973, the legislature passed the Municipal Home Rules Power Act, which dictates that local government should be allowed to act if not clearly directed otherwise by statute. And then the third thing and final thing that I want to point out is that Attorney Googleman points to a provision in section 101.361, which says that it, in support of the position that recall needs to be statewide, and the charter, in his opinion, should not be amended, or it wouldn't be consistent with state law to do that. But that section reads, quote, "It is the intent of the legislature that the recall procedures provided in this act shall be uniform statewide. Therefore, all municipal charter and special law provisions which are contrary to the provisions of this act are hereby repealed to the extent of this conflict." This was in the recall of county commission and city council member law, which passed in '74. And that what Attorney Googleman relied on, this passage I just read, has to be there because it repeals anything that preceded it regarding recall elections of county commissioners and city commissioners. So that's what it talks about in uniformity and repeal. It does. So I wanted to point these things out. I think there's plenty of time for me to file a written memorandum that further explains this in writing, but I just wanted to say those things today's meeting. Thank you.
I don't know where our chairman is going.
Thank Mr. Trettis. The chairman did have to step out, so I'll take the gavel here for a few minutes until he returns. Ms. Schmidt.
Yes. Will you finish, please?
Yes.
Okay. I want to thank Paul. For those of you that have not seen it, Paul Googleman is the attorney for this board, and he did a 19-page, I counted them, Paul, memo to this board, and going through, in particular, the school board issue, that he stated state law, attorney general, and the courts as to why this item, as far as single-member district and also as far as the recall, is not correct. And that, in fact, the only thing that the county commission, and I did mention this, I asked the question when we were here the last month, as to why this even was in the county commission charter, because the county commission has nothing to do with the school board. The only thing they do is collect impact fees for them, which they are permitted to do. And then I did have a very brief discussion and said, you know, why is this even part of the county commission charter, of one elected body telling another elected body what to do? And under Florida law, and I think he was very specific in what he laid out as far as attorney general, state law, and the court cases that have taken place as to why really this section 8 should not even be part of the county charter. That the way that you would have to go and get what you're looking for if you are on one side would be to go to the state legislative delegation. And the delegation, in fact, this last meeting or group of the legislature, Representative Fine did take a piece of legislation in on single-member districts, so I know he's a smart man, and I know at that point he had to know that the single-member district that is already in the charter was not legal or correct, or he wouldn't have taken that in. But it did not pass the legislature at this year. So to me, if you want something like that to occur, whether it be the school board or some other group, is to go to the state delegation in Brevard County and then ask one of them or all of them to take your issue in. And I think, you know, you may have a lot of people supporting you at that point. But to me, I'm basing my information on what Mr. Gugelman wrote. And anyone that wants a copy of the 19 pages, it's public information, so.
Mr. Chair.
Thank you.
Mr. Chairman, we're still on item E2B for comments. Mr. Tredis.
Thank you. Mr. Gugelman, you know, when you put in your memorandum, I think you said the same terminology for both recall of county constitutional officers like tax collector, property appraiser, sheriff. You said it was a close call, but in your opinion that would be inconsistent with state law. And then also you said for the recall of school board members, again, you said it was a close call, but in your opinion that it was not consistent with state law. I just want to ask you about, you know, your terminology, a close call. Could that mean that a court may decide that it's consistent with state law or inconsistent with state law? In your opinion, that it's that either of those things could happen if it were litigated in court?
Yes.
Thank you.
Mr. Chair. Mr. Chair. Sure. Quick question. This goes back to the same thing Blaze brought up a minute ago, because that's what I have circled here as well. One word I have circled. Item 11 in Section A. The intent of the legislature is that the recall procedures, that's what I have circled, procedures, provide in this act shall be uniform statewide. I read that as the process of recall, not the office holder or the office itself. Am I wrong?
I think certainly the court could interpret it that way. Yeah. As I say in the memo, I think this is a close call. It's unfortunately in the law, as we all know, there are not many things that are black and white. A lot of them are gray, and it causes us all a great amount of consternation. And I think this is one of the issues that fits right in the gray. It's very gray, and as the gentleman, Mr. Tredis, points out, if this were in court, could a circuit court or an appellate court determine to the contrary? Absolutely, absolutely. Now, should they? Of course not, because it's my opinion. But I think he's absolutely correct that they certainly could.
So it is fair to say that the word procedures could be defined as the process, not the office itself.
It could be interpreted to be process. You're right.
Thank you. Appreciate it.
Mr. White for a question.
Yeah, well, I just, what a surprise that two attorneys have come up with a different conclusion. And so with regards to whether or not one opinion is right or one opinion is wrong, seems to me that that's one of the reasons that we're here, is to try to weigh these arguments and to come up with a solution. And I rather doubt that every opinion on this board is going to be the same. So I think, I don't know what the whole end point of this is going to end up being, but certainly it's not to try to decide today whether or not we even continue with this discussion. Am I correct?
That's correct.
Okay. So I think we plow on.
Other questions on Section E, number 3? One thing I would ask the staff to do then, because we don't know for sure who would actually be paying for the election, I think it'd be interesting to ask the supervisor election what a special election does cost, or at least give us their latest figure on that number. As we know, there's off-year elections in cities. That maybe gives an approximate number, so at least people, again, go eyes wide open what a special election might be versus if they choose to have a recall election during the next general election or primary, whatever it might be. I think that might be helpful, just for more information's sake.
Mr. Chair, to add to that, I think it may also play into one of the later discussions we have on a proposed charter amendment as to whether it's a single district member or a countywide election, because that greatly increases the cost of an election to do a countywide election versus a single district.
I couldn't agree more. I think just that general cost for an election, a special election, is important. Countywide or by an individual district is a very good question. So we'll get that information for us. We're still on only reading 2 today, and I think one of the things I'd still like to discuss today as a group is, do we have a vote-a-rama on all the bills or all the proposals in one day at the end, or if once it reaches number 3 or third hearing, do we schedule a vote for the next meeting? That's something we should probably discuss as we go along, because the number of proposals are increasing by the hour. Please, if you give it another hour, you might get another couple more. So let me know. With that in mind, it's I think we just want to make sure before we get into actual proposals, anything on process that people want to get into today. I know later today we're going to have a vote on moving from 10 to 8 or not, and also. I think the provision was also added about all 5 districts voting for a particular proposal. That's coming later. But anything else with process before we get into the public comments on the different agenda items, starting with F?
Mr. Chair.
Yes.
I happened to overhear Mr. White say that he had to leave today at 2:30. So after hearing that, I would ask the chair's permission to do the vote from 10 to 8 in Rule 17 before 2:30.
I think there's going to be an extensive debate on that. That's the only issue. We will do our best to get there. I don't think there's any doubt about that. But I'll open that up to the committee. Would you all like to move to that agenda item now, or proceed to it in due course? Anyone have a preference? I know yours, Bob's, of course.
Due course.
Okay, all those who'd like to see that later in the agenda say A. Yes? All those who want to go right to that item now, say yes.
Yes.
Okay, we'll go to that item now. Okay, let's move down to this is an unfinished business, and it's section G, and it's on the motion to change from 10 to 8. Why don't we open up, Blaze, it's your item. Why don't you go ahead and kind of promote your idea, and then you can answer questions from it, and then we'll allow debate for it.
Thank you, Mr. Chair. I believe that I do not have to restate the motion because it was made at the last meeting and it was tabled, so that's my understanding of procedurally how it would work. But the motion was made, and the motion is to change from 10 commissioners to 8, the number that would be needed to pass a proposal to amend the Charter Review Commission in Rule 17. And the reason I've made this motion is because I had a chance to look at some of the other charters of the state, and I found that at least 4 counties, and there's 19 charter counties, at least 4 of them, only 4 I should say, because there's 19 charter counties, only 4 of them require more than a majority vote to pass a proposal. That would be Osceola County with 2/3, Hillsborough County with 2/3, Wakulla 10 or more, Broward 2/3. So the majority of charters do not require a supermajority for a proposal to pass. And I am of the opinion that Brevard County's charter should also not require a supermajority. And I think that there's also an argument to be made that it has to be 8 and can't be 10 no matter what, because the charter that exists now does not contain a supermajority vote. Silence is a majority. You look at all these counties that don't have a supermajority, their charters are silent. It's just if it's voted in. So if you, and the other thing is this is not a procedural matter. Even though this 10-vote requirement is in the Commission's rule of procedure, it's not a procedural matter. There's nothing more substantive than the vote requirement that a charter proposal must have to pass. It's really the essence, the core function, fundamental function of what this committee even exists to do, which is decide whether or not to pass proposals to go to the voters. So it's silent now, and I submit that silence means it's majority, and if it's going to be anything more than majority, then it needs to be in the charter, just like it is in Hillsborough, Wakulla, Osceola, and Broward's charter. But it not being in the charter, it's 8, which leads to the scenario that if, let's say on the charter cap amendment, if 8 people vote its approval, 8 or 9, then the chair would be in a big decision to make. There's nothing in the charter which says it requires 10 votes. So do I send it to the Board of County Commissioners saying that it's passed and to take action on it pursuant to the charter? Or does the chair say, well, what do I do now? Because there's these rules of procedure which say it takes 10 and it got 8 or 9. It's a bad predicament to be in for the chair. But then you follow it up with the chair decides that, no, I'm not going to send it to the county commission because the rules of procedure says it takes 10 votes. Then a commissioner makes a motion for the chair to forward the proposal to the Board of County Commissioners as passed. And that motion gets 8 or 9 votes, let's say. Now you have a motion for the chair to do that. So it's a real quagmire that's avoidable by changing the rules of procedure to from 8 to 10. But I submit that even if that's not done, then it's still 8 because the charter doesn't say it's a supermajority. And the rules of procedure, it's not procedural, it's substantive. So for those reasons, that's why I make this motion, and that's all I have to argue.
While we're on this subject as well, you have new business where you want to also remove with at least 1 member appointed by each commissioner. Okay, so you want to further erode that number from 10.
No, that's on a different rule. That's in Rule 16, where right now it says 8 members, but at least 1 member has to be present from each commission district. So that's a different proposal which I have not made a motion for right now.
All right, just want to make sure you're on the same page.
Yes.
Okay. All right. So I think what's being proposed, just so we're all clear, is Mr. Tredis is saying that in general, if nothing's done, it could be as simple as 8 people voting in the affirmative to send it off to the county commission. Under our rules, currently we have it as 10. I think what it pretty much calls for then is is it the will of the committee to stay at 8, have a vote up or down on that, and is it the will of the committee instead move to or stay at 10? So I think that's really the debate is on hand here, because what's being implied is that it's 8 regardless of the vote, and I think we had kind of adopted as rules earlier in our meetings at 10, or at least accepted that ruling at 10. So I think what it'll do is just open this discussion up, see where it goes. I know also Mr. Moore talked about the idea at least 9, because that's that 60% threshold which is used for the Florida Constitution. So I'm open to, again, what the commission or committee would like to do, and then we can have an up or down vote when we get there. Mr. Jenkins.
I would just like to comment that, the county charter is very similar on a local level to the United States Constitution and the state of Florida Constitution. And I think that anytime you propose changes to that, they certainly need to be well thought out. And the other point that I wanted to make is supermajority votes are very common on a lot of matters of extreme importance. And to me, the county charter is a matter of extreme importance. And I do think there's a case to be made for a supermajority vote.
Mr. Chairman?
Mr. White.
I think it's clear that we're not the ultimate decision makers on these proposals. That ultimate decision maker is going to be the people of Brevard County that choose to vote on whether or not an amendment needs to be passed. And so I think that anything that we do that erodes the ability of the people to weigh in on these decisions is contrary to what the whole idea behind a charter county is supposed to be. So, I mean, I agree with Mr. Tredis that to require a supermajority on this body will do nothing but prevent the voters to have that opportunity to speak their piece on a proposal. So they either get to vote on a proposal or they don't, based on either a majority or a supermajority on this board. So it just seems to me that a supermajority prevents the voters of Brevard County from having the opportunity to make their opinions known. I think that's the ultimate choice that we have as a body is what are we passing on to the voters and how many votes should it take. I'm in favor of a simple majority.
Other comments?
I'll defer to Mr. Tredis first.
Okay.
I think Mr.
Mr.
Chairman.
Tredis.
All right, thank you. I was on this committee recently. It was a District Court of Appeal Workload Committee, and when it came down to the very end for a vote on the matters that need to be voted on, the chair announced that he wasn't going to vote, that he was a neutral person, and surprised everyone, but at the very end said he wasn't going to vote. And, I just was curious, Mr. Chair Herodopoulos, are you going to vote? Because it makes a difference on whether, it's 14 or 15 people who will be voting.
I consider myself an equal member of the group, so
Thank you.
I'm not going to abstain or anything. Mr. Moore.
Mr. Chairman, I was going to joke with our public defender. It became clear after the first comment why he wanted to change the agenda and have it done now. He's got a good supporter in Mr. White. But if you would allow, Mr. Chairman, I do have a couple of comments for the attorney, or questions, I guess, for the attorney.
Whatever time we need to take to make sure this is right.
Paul, the Blaze raised the question as to whether or not a 10-vote requirement in our procedure was in some way a violation of the charter because it was stated there versus the charter. Any thoughts or ideas relative to this committee's ability to establish a majority or threshold that would be above the 50% plus one?
Mr. Chairman, I've not had a chance to research this issue, so my comments are kind of, I guess, extemporaneous. I think the question is, a good question is, where did the 10-vote requirement come from? And the answer to that is it goes back to the original Charter Commission. The members of that Charter Commission, in adopting their rules, decided that they wanted to go with the 10. They had a 15-member commission just like this one, and they decided that they wanted to go with the 10-vote rule. Their reasoning at the time is that they felt that if something couldn't garner 10 of the 15 votes, then its chances of moving forward in the process with the voters was probably not a good chance. As I recall, and I'm thinking back 30 years now, the rules were reviewed and actually drafted by the Charter Commission attorney, and those were adopted. So at the time, the attorney, who was Alan Watts, by the way, who's deceased, Mr. Watts' finding was that this was appropriate for the rules of consideration and for the rules of procedure. Other than that, I really can't give you a whole lot to this because I haven't researched the issue.
Mr. Chairman, I would tend to agree, and I would say to what was referenced earlier about the multiple legal opinions, there are some pretty brilliant lawyers on this committee, but there's one that we pay to represent us. I don't think any of us that sit up here, it's not our professional liability insurance, it's on the line of giving legal opinions here. So I think many opinions on this may vary, but I think I'll agree with Sue's earlier comment about listening to the counsel that we've paid to help us. But in relation to this issue, all due respect to Mr. Tredis, I stated it, on the record previously. I've served here previously as well. I do believe that it is not historically unique that higher percentages are required for changes to things like constitutions. I think Tom brought it up in his earlier comment. Our former Senate president referenced it in terms of the state constitution and 60%. And I think there's been much discussion around the state and other states. I mean, even at the time when there were such highlights of how do things like pregnant pigs end up in constitutions, it's because it was made extremely easy or easier for constitutions to be changed. We're not changing the code. We're looking at what is the functional equivalent of this county's constitution. So on that one basis, I don't think there's a problem with an enhanced threshold. Number two, I said at the last meeting relative to, yes, there are 15 members, but these 15 members are appointed by county commissioners. So each of the 5 county commissioners appoints 3 people. I think the one that appointed me sits in this audience today. So we are here having been appointed by members of this county commission. And I think the functional equivalent of 3 county commissioners, which would be a majority in that context, would equal 9 of us. And so that's at least the 9. And as Paul referenced, when this 10-vote rule was ultimately created, they went with the 9+1 as an enhanced standard to say, hey, look, we're not just going to go with a simple majority to make it out of this posture that we would ultimately need 10 versus that. And then last but not least, Mr. Tredis, and it's my fault, not yours, had I known that both this proposal and the one that you referenced to come relative to not requiring a member being present from each commission district, if I had known that changing the number of votes needed to change the rules was going to be used for this purpose to ultimately water down how the process would work, I would have lodged my dissension at that point. And so that's not your failure, that's mine. I wish I had spoken up at that time, but I certainly am opposed to reducing the number to 8 versus 10. Thank you, Mr. Chairman.
Mr. Fisher.
Chairman, just a question for my fellow commissioner down there. Are you suggesting then that the county commission that originally established the 10 rule versus the 8 or even the 9 rule didn't trust the voters of Brevard County to be able to make a decision on something as important as their own charter?
Not at all, Mr. White. I don't think we're talking about the voters' decision. We're talking about what this body sends forward to the voters. And so let me give you the 2 rationales. One, I stated why I think changing the charter, like changing any constitution, heightened thresholds would work. But the second part, and I know, Mr. Chairman, you said, and Mr. Tredis said that it's a separate item, but let me include the second part of that, which was ensuring that at least one member representing that county commission district is present. As much as we love Brevard and we are one whole, Things in Mims and Micco are different. Things Barrier Island, Beachside, and Mainland are different. And to the degree that 3 members of this board represent a county commissioner that is defined by a specific geographic district, I believe that second rule does ensure the fact that all geographic areas of the county are at least heard on anything and everything that would go forward to the voters. And so I don't think that takes anything away from the voters. And in fact, this 10-vote requirement, I think, has existed. I think Mr. Googleman would know far better than I would. But at least the last 2 times I was here, the board functioned, this committee functioned on that 10-vote minimum. So I don't think that in any way reduces, you know what I mean, the voice of the people. If it reduced the voice of the people, you could wipe out this, make it 1 vote, and let's just send everything forward for that particular purpose. I think that clearly the people still have plenty of opportunity to speak, but an enhanced threshold for this committee is not inappropriate.
But you certainly do agree, though, that a
Mr. White,
10-vote minimum...
we'll get in debate later. Let's just
okay.
let folks get their opinions out, then we'll go back and forth with questions. Mr. Fisher.
Yeah. I asked Mr. Goodman, how did they get the first original committee members get to the 10-vote rule? And there's so many things I know in our county that take supermajority vote, and usually it's stuff that has major impact on the community. And as far as I know, from a voter standpoint, most of the voters will not see this item until the day it's on the agenda. They have not vetted the issue, or not spent as much time talking about it as we have. And so they're going to depend on this board to be putting something forward that really is in the best interest of the county. And I think if you aren't able to get 10 out of 15 members on this board to move something forward, then more than likely it's not going to be in the best interest of the county. And I think most voters are going to depend on us bringing something forward that could make sense.
Others in the discussion. Ms. Tredis, discussion.
Okay, if that was the intent of the original rule, that the original charter members thought that if a proposal couldn't get 10 votes and it wasn't likely to get anywhere with the voters, I think that's a really faulty logic, because I am very confident that if my charter cap proposal got 1 vote of this commission and went to the public, it would get the same 73% or higher percentage that it got in 2008. So that's the first thing I'd like to point out. The second thing is, it seems like some commissioners think that the existing charter should be given some type of reverence, and it should be a very high hurdle to change it. Well, we've heard from our attorney that Article 8 on single district school board member elections is contrary to law. We haven't discussed that much, but I think it's going to be a lot more than a close call when it comes to that opinion. So what I'm saying is this charter it wasn't written by Thomas Jefferson, and it should be changed when it needs to be changed, and I think there's definitely things that need to be changed. I don't give it the same reverence of a supermajority vote to change it like others do. And then finally, regarding Mr. Moore's point about 3 commission districts, I personally just don't agree with that whole philosophy that we need representation for votes from each district. As a matter of fact, this commission voted to change the procedural rules, I think our second meeting, to eliminate those residence requirements in the procedural rules. So we've already made that decision. But assuming that is somehow important, 8 votes would be from 3 districts. 3 votes, 3 votes, 2 votes. That's 8. You got your 3 residential districts by 8 votes in that manner. 2 out of 3 is a supermajority. So any way you slice it, 8 is, I submit, the number that should be all that is required to pass. Thank you.
Others who haven't been heard yet. Ms. Roderson.
So this particular proposal is one that's kind of troubled me. And so I did some research about how people do change the Florida Constitution, how we change our national Constitution, all these things. And my opinion, is that there is no set bar, right? We're comparing apples and oranges most of the time. Especially here when we talk about a supermajority being required to change our charter. Right now, that's not required of the voters. We're not elected people. They pass it by a simple majority. To me, if they can pass it by a simple majority, it makes sense that the standard for this process should be the same for them and for us, to me. The county commissioners have a higher bar to change something, and if a voter does it by petition to change the charter, it's actually a much lower bar. It's 5%. So there is no standard bar at the moment for changing our charter in the county. I don't think there's a right or a wrong thing. It's just a personal preference. To me, I like it when things are the same bar for people to vote on it that it is here, since we're not an elected body. So that's just my personal opinion.
All right, others haven't been heard yet. Mr. Oliver.
I would echo Mr. Jenkins' comments that I view the charter as our version of the Constitution, and I believe that 2/3 is a proper level, just as it is in the Constitution, for the legislature to change it. So that's where I stand.
Others in comment or debate? Ms. Schmidt.
I guess I'm kind of giving away my old age here, but I happened to be on the board in 1994 when it went to the voters, and which means that the county commission at that time sent that wording to the voters in Brevard County, and the voters chose to pass it and become a charter county. And I believe it was done for a reason, and each board since that time, and there's been a lot, trust me. I'm up on that wall like 10 times or something. It really, people could depend on it because they voted for it. And to me, that makes the difference.
Others. Mr. Fisher, I know you had comments.
Paul, one question for you. Did you say that you're not positive yet that if a decision's made here and it gets to the county commission, can they reverse it or support it? Or
Yeah, we've still got that issue under research, and we'll be coming forward with an opinion on that soon.
Mr. Chair, I think it'd be, for me, I wouldn't be very comfortable voting on any changes until that question's been asked.
Let's take that under advisement, and we'll come up with that. We have a motion on the table, as you know. We can table this if we choose to in this meeting or not. But I think other people have opinions. Mr. Newman?
Yep, and I think I made part of my opinion known last time, but something that I had thought about during this whole discussion as well is kind of the more utilitarian use of what you can do with, instead of a 10-person majority, an 8. I believe, and I'm going to, Ms. Schmidt had pointed out very accurately, why was the school board in the county charter when the state has it? And because of that, you have these questions of how certain things got in there. Well, I believe at that time it was under Brevard review, but now I think that we have an opportunity to also clean certain things like that up by using this process. And usually a 10-person board, you wouldn't be able to get that down to the people in order to vote that, or in order to make some sort of cleanup proposals. On top of that, I've had the privilege of talking to tens of thousands of voters here in Brevard, and they're always wanting to be involved in the process. They're always wanting to have an opinion and be heard and go out there and vote for certain things. And I generally trust everybody on this council. I don't think that we're going to pass something absolutely ridiculous or crazy, but I do think that we would be able to send something down there, even with a simple majority, that makes sense, that's rational, or it's something that at least should be considered by the voters. Because if a simple majority of this council says, oh, hey, we're going to go down and say, do you guys have an opinion on this? I think that they would appreciate that opportunity instead of saying, oh, it was short by 1 vote and only got 9 instead of 10. Now the voters do not get to have an opinion on that. They have to wait 6 years. Or Ms. Rogerson put together, I guess, how the petition process, which I've gone through a petition process, very difficult for a voter to actually get something, whether it's involving the school board, whether it's involving ability to speak, things of that nature, in front of the voters through the referendum process. So from a utility perspective, I think it could help us change some things, clean some things, give more voters opportunity to see things. And again, I trust the people on this board, so I think a simple majority is A-okay.
Mr. White.
Yeah, I may be shooting myself in the foot here, by even asking this question, but of Commissioner Schmidt down there. When the county commission voted to send the idea of a charter to the voters, was a supermajority required? Were 4 votes? Were the 4 votes required of the 5-member board in order to make that happen, or was it just a simple majority decision?
On the county commission?
Yeah, when you said that the county commission voted to send it.
It was a simple majority by the county commission to place that on the ballot.
Did you say simple or super?
Simple.
Simple. So 3 out of 5.
Now, the commissioners themselves were not simple. Okay, because I was one of them.
That's not what I was implying.
I mean, we have to have a little levity, Bob.
I know. I'm smiling.
But
it did not require a supermajority of the county commission to send the idea of a charter
not
government.
at that time, because you did not have the charter yet.
Okay, I'm just asking. So 3 out of 5 could do it.
Other comments on the issue? All right, let me just add a couple things. And one is, as was mentioned by Mr. Moore, I've lived through this on both sides of the issue. When I was first elected to the legislature, they passed the train initiative. This is the idea where you would have to build a train constitutionally, et cetera. And because of this and the pregnant pig issue, we in the legislature decided to have a higher threshold to place something before the voters in the Florida Constitution. The same thing held true, of course. This would be the equivalent, of course, on the local level of having a supermajority. I think the other thing that a lot of people have talked about, not on the legislature, but in representative bodies, is having a higher threshold when you want to raise taxes. Everyone's for having that higher threshold when you want to raise taxes. One of the things I'm always concerned about when we mess with the United States Constitution or the Florida Constitution or even a local charter is the unintended consequences. And I know there are a few proposals that are coming here that would be very expensive if they should pass. And I think that's one of the things where the higher threshold is always of, I think, importance. And so I almost like be careful what you ask for. I think the other part of it is we're having this discussion, actually as we speak, in the United States Supreme Court hearings right now, talking about are you a strict constructionist or are you not? And so what we're talking about here is when we lower the threshold, that you're making it easier to change a fundamental document. And so I just want us to be kind of wary of that, or if you're on the other side, you're optimistic about it. So it's something you can do. I think based on Mr. Fisher's question, which I think is a fair one, is the last thing I want to do is change the rules of procedure and then find out later the county commission is going to sink it based on the fact that we didn't have a supermajority or whatever it might be. So considering we have no votes today of consequence, meaning we're not voting today to send it off to the county commission, I would think the logical thing to do would be to table this motion because we're not voting. And I want to, as I said in day one, I think we all agreed with, is we want people to have a very informed decision when it comes to their ultimate decision. And so we should do the same in this process. So if it's okay with the committee, I'd like to entertain Mr. Fisher's motion that we table this issue until we find out more clarity from the legal side, because I don't want to send whatever we send if it's just an 8-person majority in the end and get them all nuked and we all wasted half our summer. So do I have a second on that?
I'll second that.
Okay, Mr. Oliver seconded. All those in favor say yay.
Yeah.
All those opposed say nay.
Nay.
The ayes have it, so we will table this motion till the next meeting. All right. Blaze, we're going to take up your other issue on Rule 16. We could take it up. I would imagine we're going to table that as well, considering we're having this bigger discussion. So let's show that table. I know you have to leave, Mr. White, as well at 2:30, so I want to be conscious of that so we can get as much meeting as this, as much of the meeting move forward as possible. So let's move back to item F, which is the charter cap, and we are in public hearing number 2, requesting public comment on the charter cap hearing number 2. So we have Sandra Sullivan here, who is asked to speak on the charter cap. Ms. Sullivan, welcome.
Thank you.
And we've been giving people, was it 3 minutes? Okay, yeah. 2 minutes? Okay.
That's the rule that we have right now.
Okay.
Sandra Sullivan, South Patrick Shores. So I have attended county commissioner meetings for over 3 years, and one of the concerns I have is the number of tax increases we're having related to the tax cap, charter cap rather. I think they want to do away with this so they can address essentially higher taxes on property assessment, property taxes. A year ago, they looked at, in the Budget Review Committee as an example, that they had a lot of growth and they needed to fund that growth, and they were looking at bonds for utilities. A year went by and we just had a utility increase, 8% for most residents, 13% in some other areas over each year for the next 5 years. And so when we're looking at the future with a lot of inflation coming, there's a lot of pressure to do away with the charter cap. But I think there's some inequity here, because I think there's a lot of pressure coming from the developers to not pay their share of impact fees. Impact fees have not been increased. Some of them haven't been increased since 2000, and some of them 2008. In 2016, we had an impact fee study, for example, for transportation that recommended a 66% increase. That was not passed, and at that time, development had exceeded the boom prior to the crash. And so I think prior to consideration of a charter cap, we should be addressing the impact fees and looking at where the county stands financially prior to putting the burden on the residents of Brevard to pay for growth. Thank you.
Thank you. Are there questions? All right. Seeing no questions, we have, there's no one else here on the charter cap, unless you'd like to be heard before we go to the next item. Anyone else on the charter cap? Okay, thank you. All right, let's move to the second item. And that is the recall of school board members. This is our first official public hearing. We have 2 more to follow. I have about 15 cards on that, and so we're going to allocate 2 minutes for each person. And after each person is done speaking, if anyone on the commission would like to ask a question of the presenter, that is, of course, welcome as well. So let's start with Katie Delaney from Cocoa, Florida.
I apologize for my speed reading. Good afternoon, committee members. I'm here in favor of updating the county charter to include school board members to the list of elected officials that are eligible for recall in Brevard County. We are currently dealing with many issues within our district due to poor leadership and decision making. Due to time allowed, I would like to focus on 3 of these many issues. The first is finances. Right now, our school board has a debt consolidation loan that will total $512.7 million. They're mismanaging our funds. Second, according to the district, there are more than 50% of our students that are below grade level in math across the board, regardless of race, age, and gender, and reading isn't much better. Thirdly, I want to bring to your attention and to the state attorney Phil Archer's attention the fact that BPS is currently in violation of Florida State Statute 847.012, 847.001, 1006.3. With each violation, a third-degree felony is appropriate. They are currently distributing sexually explicit content to our children of ages 11 and up. 2 out of the 5 school board members don't see an issue with rape, pedophilia, explicit sexual acts being described to our children in Brevard. They should all be removed immediately and held accountable for endangering our children. Parents and taxpayers need a pathway to remove harmful or neglectful people from the school board. If recall is not an option, I am calling on Phil Archer and Sheriff Ivey to prosecute these people to the fullest extent of the law. Thank you.
Thank you. Are there questions? Also, if you wish, what we did in the last meeting is, if I know you had more remarks to make, if you share those with Melissa, she'll share those with the committee, that whatever you've typed out, because I know there's limited time otherwise. So feel free, and that goes for everyone, of course, here. We only have so much time, so if you have your talks or our presentations, feel free to share those with our staff, and those will be disseminated not just to us, but it can be done publicly.
Thank you.
Thank you so much. All right, Amy Nisi. Welcome.
It's weird being down here. Yeah, I prepared for 3 minutes also, so I'll talk fast. Okay, hi, I'm Amy Nisi. I was the School Board District 3 representative from 2004 to 2016, and my goal was to go off and be a private citizen and never be heard from again. But last year, I filed a First Amendment lawsuit and led the charge against Brevard Public Schools, and so I'm here today to tell you why, and why I believe the recall needs to be added to the county charter, and I want you to know exactly what's changed. Just to first start off, let me explain how school board meetings now start across the street. At the beginning of every school board meeting and prior to public comment, the chairman reads a statement that all audience members are subject to arrest, up to 6 months in jail, and a $5,000 fine if the chairman deems them out of order and has them removed. That's the welcome all audience members get. Then when it comes time to speak, you're told that your comments can only be addressed to and only the chairman. And get this, you may not address, state the name, or even look at the other school board members, or you will be immediately stopped from speaking. Your comments cannot be, and I quote, personally directed, abusive, obscene, or irrelevant, and the chairman's the final judge. So as I'm looking at you today, I would be called out of order. One example I can give you that counts as a violation is the chairman found the words liberal left as being offensive and stopped the speaker from continuing. The audience also has special rules. They're not allowed to make any noise or sound, and if they do, the chairman will clear the boardroom. And yes, this did happen. 2 people were allowed. The chairman cleared the boardroom. The board went back into meeting, locked the door, and none of the audience members were allowed to return. So they had a meeting without the public present because of 2 audience members. The public policy speaking was changed to discourage people signing up. If there's 10 people or less.
I have a question. Could you go on for a minute, please?
Pardon?
Can you please go on for 1 minute, please?
Okay.
Thanks.
If there are less than 10 people, the speakers get 3 minutes. If there's more than 10 and less than 20, you get 2. If more than 20 people show up, all speakers only get 1 minute. If you're not on topic, you're moved to the end of the meeting, and for a period of time, the board actually had the cameras turned off so people watching from home could no longer see. I'm going to jump to the end because I wrote down comments that board members have made at meetings. These are the things they've said. I wish we don't have to have any public comment at our meetings. I don't have time to do my job and listen to the public. These meetings are for us and not the public. And my personal favorite that I'll close with, if someone wants to talk to me, they need to call, email, or set up an appointment. That is the attitude. That is why I'm not a private citizen anymore. That is why I've hired the Institute for Free Speech out of Washington, D.C. that's representing me and several others. We can't wait 4 years. And that's why I'm here advocating for a recall, because it's become that bad now across the street.
Thank you. Are there questions?
So how long has this been going on? How long has this concern been?
Since January of last year.
Okay. And are your issues with one particular member, or is it the group as a whole?
It's the group as a whole. The group as a whole voted to approve their new policy.
Okay.
So no, this is not an attack, as some have led to believe that this is an attack against one particular board member. No.
Have you, because you're obviously very experienced, you've been, around this for a long time. Do you think that there's any motives on the part of the board, or if there is, what those might be?
I think the motive was made very clear even as recently as Tuesday night's board meeting.
Okay.
They do not want parental input. One board member Tuesday night, they were trying to figure out a way to give other people more time that got pushed to the end. One board member suggested, well, let's allow employees to have this. Another person said, well, let's allow students. Not one of the 5 board members ever used the word parents. Parents are not welcome. Parents are not included. And as you can see from the comments, we're told very clearly, if you want to speak to us, and I think one of them said, this is not the place to speak to us. We don't have time.
Okay. And you said that you filed suit, right?
Yes, the suit was filed last September. We've been to court for an injunction. We're headed to mediation, but the case is ongoing, and our case has led to several, not only in this state, but across the United States.
Okay, all right. So do you know what the case name is by chance?
I don't have it here in front of me. If you want to contact me, I can.
If you don't mind, why don't you share that with Melissa when you get it?
You can actually, if you Google Institute for Free Speech, there's a link with the website with all the court documents on there with our case.
Okay, thank you. And I'm assuming a lot of what you brought up today is going to be contained within the documents, right?
Yes, it is.
Thank you, ma'am.
Thank you. Other questions? Mr. White for a question.
Yeah, just very quickly, is there a phone number or an email that we can get a hold of you directly?
How about if I have no secrets. It's to Amy Nisi, but my phone number is 321-720-0123.
Thank you very much.
Mr. Newman for a question.
In relation to you said that there were new rules that were put in that was voted on by the entire board. Was that, I'm remembering that they had limited public discussion back in October, if I recall.
Correct.
Is that after that, or is that those rules that you're referring to?
Those are the rules.
Okay. And then, I don't know if this is Jermaine, I'm going to kind of lean on you on it. Sure. Are we able to send any kind of, or discuss having a free speech motion? Where I'm seeing a different issue here than recall. I'm not trying to hijack your issue.
Oh, no,
But to me, it seems like you're not even given the opportunity to speak, be heard in a way that's consistent with the meetings. I'm a former city clerk.
I was told the only legal recourse, because there isn't a recall for school boards that we could access. We either had to wait for new elections, or we had to file in federal court, and I found the best law firm in the country, which is out in Washington, D.C.
Right. And I guess the question I'm getting at, is it possible, I don't know if this is something I could ask the attorney to look into, are we able to entertain a proposal that would allow for public comment to take place in the same way that the rest of the meeting is taken care of? So if there's a agenda item, say F1 or F2, are they able to have public comment at that level just like they are at F1, F2? Is that something we could send to the voters? Are we able to ask him to look into that?
We can look at anything you want.
Oh, okay.
We would take any and everything, but I mean, I didn't have time on here, but they've even limited the number of people in the boardroom. There's a large room behind the boardroom that when I was on the board, we opened up for people to participate.
Sure.
That's no longer allowed. The doors are locked and people are kept outside.
Oh, sure. Oh, no, and I'm a former elected city clerk. I've stayed late into the night for meetings. I get it. It's, I'm definitely personally concerned
The purpose of the new policies were, as board members said during the meetings, we will not stay late any longer.
Okay.
Thank you. Other questions?
Anybody else?
Thanks, Ms. Cece. Great to see you. All right, next we have Chris Bird. We could do that, yeah. Welcome, Ms. Bird.
Thank you. Good afternoon. I just want to express my gratitude for the opportunity you've given tax-paying citizens to redress their grievances through updating of the charter to allow for elected school board members to be recalled. When any elected official is in non-compliance with the law, what other remedy is there? Citizens shouldn't have to wait out that school board member's term to vote them out. The only fair remedy is clear: a timely ability to recall that school board member. Thank you.
Thank you, Ms. Bird. Other questions for her? Thank you. Crystal Casey. Welcome.
Thank you. Good afternoon, committee, and good afternoon, Chairman. Thank you for having us today, and I'd like to say thank you all very much for considering the recall of the school board members due to the noncompliance with state laws. And in addition to prior comments, I'd like to say in agreement that your citizens' voices need to be heard. And in several cases, as has already been presented to you, we've not been given the opportunity for our voices to be heard. So it's very important that your constituents have a voice, that it is not in any way, shape, or form watered down or diluted in any way, shape, or form, that these issues are brought to light so that your citizens have the opportunity to vote on them. So thank you very much for your consideration and for your time to consider the recall of the school board members for BPS. Thank you.
Thank you. Any questions? Thank you very much.
Okay.
We have Sarah Mirsky. Welcome.
Thank you. Good afternoon, Chairman Herodopoulos and board members of the County Charter Review. I am Sarah Mirsky, wife, mother, registered voter, taxpayer, and constituent of Brevard County. A group of us have been deeply in contact with our Brevard delegation, and they have advised that because we are a charter county, it is written within the county's authority to make this amendment to include school board members. I'm speaking in favor of adding school board members to be able to be added to be recalled. This is not a Democrat or Republican issue. This is a bipartisan issue. When school board members do not follow the law or have broken their corporate fiduciary responsibility or go against their oath of office to uphold the Constitution of the United States, the voters of Brevard County should be able to recall said school board members. An example of recalling school board members is what the voters of San Francisco, California did. They recently recalled 3 school board members, and San Francisco has a different political landscape than Brevard County. However, the Brevard Public School Board recently enacted a public input policy that goes against our First Amendment constitutional right. That is one of the major reasons why the 3 board members from San Fran were recalled. The BPS board is also currently going against a Florida state statute by having explicit materials in their school libraries. I actually appreciate the fact that a recall process can be difficult and has a time frame and has to go through checks and balances. All we are asking is that we be given the opportunity to do this. The voters, taxpayers, and constituents should be able to recall school board members in Brevard County. Please add school board members to be able to be recalled to our county charter. Thank you for your time.
Thank you so much. Any questions? Thanks for your time.
Thank you.
Diana, your name's, okay, great.
I read like a doctor.
Okay.
Or a lawyer, whichever you choose.
Thanks for joining us.
Thank you. I'm not here to educate you, but I would like to read something into the public record. It's the word malfeasance. The definition: misconduct or wrongdoing, especially by a public official. Evil doing, the doing of that which ought not be done. Wrongful conduct, especially official misconduct. Violation of public trust or obligation, specifically the doing of an act which positively is unlawful or wrongful in contradiction of malfeasance. So, it is the doing of an act which a person ought not to do, evil conduct, or an illegal deed. That is malfeasance. Official misconduct could be violating the lawful and legal executive order our great governor put in place by banning mask mandates in schools. That might be malfeasance. Evil doing could be the failure to protect our children from early sexualization, sexual abuse, or sexual deviation. That might be malfeasance. The violation of public trust or obligation could be the misappropriation of school board taxpayer funds to pursue frivolous and vindictive lawsuits or create lawsuits as might be a result of the wrongdoing. All of that may be malfeasance. We, the taxpayers, have a right to take public officials and call them to task and remove them if they fail to do their due diligence or follow the wishes of the taxpayers and the law. Our school board is violating the public trust and the laws on so many levels that we are entitled to have the right to remove these individuals. We shouldn't have to endure their illegal activities or anything for a total of 4 years without having avenues to remove them. And that's all I have to say.
Thank you so much. Questions?
Thank you very much.
Thank you.
Thank you.
Carrie, take us over there.
Carrie Tkach. Hi, good afternoon. I'm here today before you to ask that you seriously consider adding a recall option to the county charter. It's incredulous that there is no path for parents and taxpayers to recall school board members. My biggest concern, other than our First Amendment rights being violated by our present board, are the sexually explicit material available in schools. As of today, our schools continue to carry pornographic material in their libraries. This was brought to light as recently as Tuesday at our last school board meeting. Concerns coming from parents and taxpayers alike have not only been ignored, but met with animosity from some of our school board members. References to some of the children having access to TikTok on their own time are used to justify having the material in our libraries. It is against Florida Statute 847.12 to do this. It prohibits an adult knowingly distributing a minor pornographic material. Additionally, yesterday, a teacher from Stone Middle School here in Brevard was arrested for 5 counts of distributing harmful materials to minors, as well as an unlawful use of a two-way communication device. So not only is pornography present in our schools right now, but we have teachers distributing it to students. This while one of our school board members has vocally defended the explicit material in question, despite concerns voiced by their constituents. It is imperative that parents and taxpayers have a path to rectify the blatant misrepresentation from their board members. Waiting 3 more years for the next election is 3 years too long when it comes to the well-being of our children. Thank you all for your time.
Thank you so much. See you on the questions. Thank you. All right. Pamela Castellina.
You get closer every time. It's Castellana, but you get close. Good afternoon. I actually have 15 copies, so you don't have to disseminate them.
Thank you.
So I was recently accused of being rude to the members of the board in February. What's rude is intentionally misleading the public, which Mr. Tredis appears to be doing. I'm not opposed to the concept of recalling school board members. Go on the record. His excuse for ignoring all precedent state statute is as follows. The school board's face mask requirement was voided only because Governor Ron DeSantis and the Florida legislature passed a bill in special session in November 2021, which prohibits a school district board from requiring a student to wear a face mask. If Governor DeSantis were not the governor of Florida, then Brevard County public school students could have had to wear face masks in school indefinitely, as students are now ordered to do in states like California and New York. At the February meeting, I gave Mr. Tredis the benefit of the doubt that he was simply ignorant of the facts and had not taken the time to glance at the minutes of the school board meetings. So I presented those facts as followed. The mask policy, as approved by the school board last year, was never indefinite. On October 4th, the Brevard School Board set metrics in place, giving the superintendent the power to rescind the policy when Brevard County's positive case rate reached 50 out of 100,000 cases. That allowance was approved by 3 of the board members, Misty Belford, Cheryl McDougall, and Jennifer Jenkins. The threshold was reached 2 weeks later, and the opt-out was added well in advance of DeSantis' overreach. Tredis has neither withdrawn nor edited his request and his rationale for it. I can only assume malicious intent at this point rather than ignorance. To say this is not politically motivated is demonstrably untrue. On June 30th, 2020, County Commissioner Brian Lober asked for a mask mandate for our entire county, yet I don't see any attacks on the county commission's ability to serve their term. And finally, even Mr. Lubko agrees with me, miraculously enough. He recently posted on social media under one of his aliases that we don't recall people based on just their party or a vote. It takes malfeasance. It's a very high bar. Not just passing a local ordinance, recall, and I have a screenshot of that post as well as evidence connecting this alias to Mr. Luker.
Okay, thank you, Ms. Costello.
Any questions?
I have a question.
Other questions? Mr.
Yes,
Tredis for a question.
So you do know that Mr. Lober could be recalled according to Florida state law, don't you?
Yes, I do.
Okay, so the voters already have that ability to recall him for his decision, but they do not have the ability to recall school board members,
I don't have a problem with the ability to recall the school board member. My problem is that your entire premise of it is based on a misstatement of the facts.
Well, that was just,
you claimed that they would still have masks today, if not for the governor's executive order, and that is not true. The parental opt-out was put in place well before the executive order was approved by law.
Okay. Well, that was just one reason.
The
other reasons are matters such as the transgender policy, the public school system here in Brevard County, which allows kindergarten through 12th grade to use the same bathrooms, locker rooms, and shower with children. of the opposite sex. Do you approve of that policy?
That's not the policy I'm addressing in my statement. I'll be happy to address that with you at the next meeting.
Well, that's one of the reasons why this proposal is submitted. So, do you approve of that policy?
My disapproval with you is about the fact that you are misrepresenting the facts on the mask policy.
If I'm wrong on the facts,
are you agreeing or disagreeing with?
If I'm on the wrong,
Mr. Tredis, hold on. We just do one at a time. Please complete your comment, and then once he starts talking, you can respond. Finish your comment.
Do you agree that you are misrepresenting the facts of the mask mandate, Mr. Tredis?
I may have been wrong on the facts, and if I am, then I was wrong on the facts. If you're right on the facts, then you're right. I don't know. The facts, I guess, speak for themselves. So if I was wrong, I was wrong. I don't have any problem saying I was wrong on the facts if I'm wrong on the facts. But it's just really a little part of why this proposal was made by me, okay? The school board did order mandatory mask wearing. The timeline, when it went away, when it didn't, that's not all that important to me, quite frankly, because they ordered it against the governor's executive order. That's what's important to me.
May I respond? Actually, it may not be important to you, but it is important to many, many voters in our county. In fact, there was no surprise on Jennifer's stance on mask mandates. Her entire campaign was run on that. And in fact, if I had finished my statement, a recall is and should be a high bar. When Mrs. Jenkins won her election, her stance on the need for a mask mandate as the only life-saving strategy available to our school board was widely known. She had stated in public debates, interviews with the newspaper, and even conservative radio talk show host Bill Mick. And Mrs. Jenkins won that election with 54.6% of the vote to her opponent's 45.4%. That was the recall that mattered. I served as her campaign manager, and we even had a state representative's wife tell us that was why she voted for her. So I understand it's not important to you, but it is important to some of the voters, and the reality is that you misrepresented those facts as they stand. And I presented them to you a month ago, and you have not edited them, so you continually are misrepresenting those facts. That's what I want on public record.
Thank you. Mr. Tredis, do you want to finish up? Or?
No.
Mr. White, for a question.
Yeah, Mr. Tredis asked you a simple yes or no question. I was just wondering if you could yes or no.
No, I don't want to answer that question, but thank you.
Well, you said that you included it in your.
No, I did not include any comment on the transgender policy as passed by the federal government and approved by our former school board.
Why did you tell Mr. Tredis that it was in your report?
I didn't say it was in my report. I said I'll be happy to address that next month. In fact, it's on record what I said. Could you read it back?
Let's just like we did just a minute ago. Let's let one person talk and then the other. Okay, Mr. White, for your question. I'm sorry.
Yeah. He asked you a yes or no question. It was my understanding that your response was, I addressed that in this report that I'm leaving behind.
That's actually a misunderstanding. What I said was I did not address that today. I'll be happy to address it at the next meeting. And I believe we have words being transcribed here, and that could be read back.
It's a simple yes or no.
You can't badger me all you want, Mr. White.
You're badgering everybody on this. You're badgering everybody up here.
Okay. Thanks for your time. It's great to see you.
Thank you, Mr. Havanopoulos.
All right. Karen Colby.
Mr. Speaker, can I make a quick comment?
Mr. Wheeler.
I just want to say, and Blaze, correct me if I'm wrong, it was my understanding when you put this forward, you had very strict rationale, malfeasance, failure to do your job, or the commission of a felony. I don't see how masks really are that big of an issue and why we're having that discussion. If we're talking about recalling somebody, it's because they did something big, and that's my understanding where you were coming from with this. Am I wrong?
The proposal actually includes malfeasance. But the second grounds is the up to 3 votes by a school board or school board members. And the reason I put that in there was because the statute that the recall proposal is patterned after is very vague. It has reasons like drunkenness, incompetence, misfeasance. And if you look at the litigation under the existing recall statute, that's usually where the litigation is, and that's usually where it's stricken down because they're so vague and undefined about what is incompetence, what is misfeasance. So they're stricken down. So what I wanted to do was make it perfectly clear that here is a transcript of the motion that was made and the vote by the school members. So if people want to remove a school board member because they, in fact, want children of all ages to use the same bathrooms, showers, and locker rooms, they will have the opportunity to do that because there's a motion in the record and the school board members vote on it. That's why I did it the way I wrote it.
Thank you. We have Karen Colby.
I didn't want to get yelled at for that.
Welcome.
Hello, Karen Colby on Beachside, District 3 for School Board. About the recall petitions and all that, we're not given any other recourse. I know someone else said that, except for to change the charter. Back in 1865, the colonists were not allowed to choose representatives in Parliament in London. They passed laws on which they were taxed. This led to taxation without representative, culminating in the Boston Tea Party in reference to the Stamp Act Congress. So in 1765, they declared that the English crown was not going to be able to represent them anymore without them having their own representation over in England. These were the colonists. So that started basically the Revolutionary War. In other charter counties, these call for removal of school board members. It affords a remedy. We don't have a remedy. A remedy is needed in an untenable situation. I would emphasize that this isn't a direct attack at any one individual. This is about our rights to use our 1A in the First Amendment to stand up and say that we insist that these individuals follow Florida law. Our governor said that they are not to mandate children into masks, which they did. Other states are trying to mandate vaccinations. We need to stop this now so we can remove anybody that tries to mandate vaccinations. This is a right that the taxpayers have because we fund the private schools and the public schools get money from our taxes. If we don't have the right to stand up and say something, it's taxation without representation, and that's tyranny.
Thank you, Ms. Colby. Any questions? Thank you so much for your time.
Thank you.
All right, Jonathan from West Melbourne. His handwriting is very unique, so it's Maikisch. He must have left. All right, Michelle Barano. Welcome.
Thank you. It's my first time here. This has been a very interesting experience. I'm a Brevard County resident, mother of a Brevard County school attending child. I don't think recalls are necessary. We have a mechanism for deciding who serves on the school board. It's called an election. It's ironic because I've heard several quotes here today. I'm very sorry Mr. White had to leave, talking about the sanctity of the vote. He said that the reason you didn't need a supermajority for the commission is because the people who decide are, quote, people of Brevard County that choose to vote, unquote. Okay. Another gentleman over here said you said people could depend on it because they voted for it. And then another person said that the voters were involved in the process because they wanted to be heard. I came out, I voted for my school board member. She happened to win. Now, people who are in a very vocal minority who aren't happy with that feel that they're living in a tyranny. I'm sorry, elections have consequences. There is a winner and there is a loser. Throughout our country, recall measures tend to fail. Only 5.5% of recall measures are successful. In the process of going through a recall, there is an extensive amount of resources being wasted. You've heard people talking about their problems in our school. Let's focus on fixing those problems. Let's not run for the same office every year, okay? That's a waste of time. I've heard people talking about who's going to pay for the recall election, whether it's going to be the school board or somebody else. I can tell you who's going to pay. I know the answer. I'm going to pay. You're going to pay, you're going to pay, we're all going to pay. The taxpayers are paying for it. We already paid for an election. There was a result. Let's live with it. I don't want to be involved in a never-ending process of the same people trying to fight for their job. And I didn't come prepared to talk about the freedom of speech issue that I heard mentioned. I would love for somebody to ask me a question because I was at most of those board meetings and can give you a different viewpoint of what actually happened in that room.
Other questions? Ms. Luber, go ahead.
I'll give you that opportunity.
Thank you so much. So this gentleman asked what the motivation...
No, let me ask my question.
Okay, I'm sorry.
Thank you. Appreciate
Please.
It. You say you're opposed to recall.
Yes.
So that everybody, all offices?
I think either everyone elected should be recalled or nobody should be recalled. And why is our governor not allowed to be recalled?
So you're opposed to recall?
I think it should be
just,
consistent.
It should be everybody or nobody?
To be honest, I'm inclined not to recall because there already is a mechanism in place. If somebody breaks the law, they will more than likely be arrested, and there is
that's one of the mechanisms for recall.
There is absolutely. Well, it's not. It's a removal from the job. It's not a voter recall. There's a difference.
But that's also a mechanism for recall.
Right, but asking the voters to come back in and change their vote, that's a whole
Why
separate
shouldn't
thing.
voters have final say and accountability on who their elected representation is?
They should. They did. They came to the polls. I went to the polls and I voted. Now you're saying it doesn't count because 10 people in the room who are allowed don't like it?
That's not the same as recall. Going to the polls and voting for someone, you're voting on policy. You're voting on politics. They haven't done anything wrong up to that point in time. There was no malfeasance.
Correct.
There was no not showing up to do their job. There was no felony committed. Once those things happen, the voters still have to have a mechanism, accountability.
And they do. You can remove an elected official for malfeasance. It's written in the law.
Again,
there is a mechanism.
I'm good.
It's already there.
Mr. Chair, I'm good.
Okay. So finish your thought. I just want to make sure it's one person talking.
I'm sorry.
Okay. Finish your thoughts, please.
So I was at the school board meetings, and that gentleman asked what the motivation was for cutting the time down to 3 minutes, having the person address the comments. It was the safety of everybody in that room. That was the most unpleasant environment I've ever been in. My husband didn't want me to go to the next one because he thought there were going to be shootings. I have never seen such rancor and venom. And that few little discourses that we've seen here that have gotten heated, that is a drop in the bucket to what was happening in those school board meetings. The chair did the right thing by trying to calm everyone down and attend to the business of the school board meeting. That was the function. It wasn't for people to get up there and scream at each other. And in terms of removing people's First Amendment rights, everybody has 3 minutes. Guess what? There was one meeting when there were about 300 people there. Not wanting to work late is one thing. Not wanting to never leave the building is another. Everyone got treated equally. Everyone's time got cut equally. Everyone had a chance to get up to the microphone and speak. I'm sorry it was 1 minute instead of 3 meetings. Come back to the next meeting. Write an email. I've written tons of emails to the board. I get responses back. No one's freedom of speech is being removed here. Everyone's being treated equally. You have a chance to speak. You don't have a chance to yell, call names, threaten, and disrupt the room. You need to be respectful, correct? So all of those things that I heard, I was at many of those board meetings, and that is not what I saw. I saw a board doing its job in an incredibly difficult, heated situation, and I applaud them for showing up because it was scary. It was scary in that room.
Thank you so much.
Mr. Chair, I have a quick question.
Ms. Broderston for a question.
Thank you for coming and speaking today. You, in your comments, addressed members of our board by name. People who address our school board aren't allowed to do that. Do you believe that that's correct?
I don't think it's a reason to recall somebody.
But we weren't talking about recall, right? We were just talking about freedom of speech. So I'm just curious your thoughts on that matter.
Yeah, I could see being allowed to call people by name. I don't have an issue with that.
Okay, so you agree that the school board is violating that part of that?
I don't think they're violating. I think they made a judgment call that I disagreed with. I don't think there's a law anywhere that says you have to be allowed to call someone by name. Is that... I mean,
I would argue that's part of the First Amendment, but...
You can say the gentleman 3 people to the left and everyone knows who you're talking about.
Yeah, but you're not... They even stop you from doing that at the school board.
Honestly, do I consider that a limitation on my freedom of speech? Yeah, it's me. It's my opinion. I have freedom of speech just as everyone else in this room
Isn't
does.
this great that everyone can just talk here? This is fantastic.
It's awesome.
It's freedom of speech, and I fully support it. I don't have a strong feeling on that. I can see how it might be construed as interrupting with somebody's freedom of speech. But again, the point of this commission here is not to decide how the school board functions. It's whether or not you have the legal ability to allow for recall. And I don't think someone not letting someone else use their name is reason to undo an election and to cost us $200,000 to $250,000, because I checked with the Board of Elections on what it would cost. And that is a waste of money. And I can promise you that what's going to happen if we go down this path is we are going to spend all of our time rerunning elections, and we will get nothing done. And we've got important work to do in this county, and we need to focus on it. We may not agree on everything, but let's at least try and get some stuff done and try and be civil to each other. And everyone has a chance to speak. I will listen. I don't have to agree with you. And you know what? If you came out and you voted for somebody else, they won, You won this time, and I have to suck it up for 4 years until I get another chance. That's the way this works.
Thank you so much.
Thank you.
Thanks. All right, we have Sandra Sullivan, our last speaker on this issue, unless someone else would like to sign up on the card there.
Mr. Chair, before she goes, can I ask a quick procedural question for Mr. Tredis on how this would function? And the reason I'm asking is malfeasance is the one ground that your petition so far has brought forward for the recall. And who defines that malfeasance? Does the court have to define it before it goes to the voters for the recall, or is it simply the approximately 4,500 voters that have to sign the petition, assuming we remain a multi-district school board, because there's about 450,000 registered voters?
I believe that malfeasance has to be described in the petition. So that's how that works. It has to be particularly described. But that was the only grounds in the Florida statute, I thought, that has some definitiveness to it. You know, I've defined malfeasance as a public official acting against the law, basically. So that's why I left that one in.
But as we've seen sitting here, a lot of people have different views of the law and what would count as malfeasance. What I'm concerned about is that what happens when a petition comes in and there's an injunction put in place to say that what they're grounds for is not really malfeasance under the law. Then it gets into an argument of the interpretation of the law. Does it go to the voters before that? Are we left in limbo after that vote? I just trying to understand the proposal.
What typically happens, I've seen from just doing a little bit of research, is that the elected official who is the subject of the recall effort files a lawsuit and makes all the arguments that you're making, and the courts decide, which is, I think, another good reason to limit the number of grounds for recall. But again, I really don't think there's going to be any argument to be made by someone to try to challenge a recall effort when it is a transcript of a motion that was made and their vote on it. And it does allow the public to remove recall elected officials or school board members for the decisions they make. And I think that should be allowed, especially when it's mask mandates, vaccine mandates, transgender policy like here in Brevard Public Schools.
Simply put, my concern is that one person's idea of malfeasance on the petition side may not meet the court standard level of malfeasance as is in court case law. Then it would just trying to get some clarity of how we get there, what the procedure would be. Is there a halt put on the county going through the expense of hosting a special election to find out that actually the motion that was put forward, that's not actually malfeasance under the law? So I'm just trying to get my hands around that expense. When it's incurred, who decides what is malfeasance?
What's happened from what I've seen is a lawsuit is filed by the person who's being challenged by recall, and the courts will make the decision.
And can the court make a decision now on a writ of mandamus function to, if a elected official is refusing to do their duty or act not in accordance with the law, can a court issue a writ of mandamus to force that elected official to do their job?
I personally, Mr. Googleman might have a different opinion. My personal opinion, that would be extremely limited because elected officials have great discretion in their decision making, and I really think it would just be incredibly rare where a circumstance, an elected official has to do something according to the law and they're not doing it.
Thank you.
Thank you. Ms. Sullivan, welcome.
Yeah, good afternoon. Sandra Sullivan, South Patrick Shores. I thought it was very relevant by the D2 rep here that there are other charters here in Florida that have the ability to recall school board members. I'd like to compare and contrast to term limits. Here in Brevard County, 77% of voters voted for term limits, but previously, some of the other charters that are in existence, they had put it in their charter and it was deemed unconstitutional for a while. It went to a higher court and it got resolved and it was deemed constitutional to have term limits. So there's a process. I'm a parent. I was a parent of 3 BPS students when I was going to those meetings. They changed the policy that, in my opinion, limited my First Amendment speech. Anything that is not an agenda item, you are only permitted 1 minute. So as a parent who has an exceptional student with a disability, and I have an issue and I need to go to that meeting and I need to convey and make them aware, I am very limited into that 1 minute. If I send emails and I don't get responses, which I can say is most of the time, that is my recourse to go to that public meeting and to speak. And so I am in agreement. We have some issues in the school board in the responding to the parental issues, and having that option, even if it is later challenged, but it's already on a couple charters in other counties. And so I don't see that it is a very heavy risk for Brevard County to consider this. Thank you.
Thank you. All right. That concludes our comments on the school board members. And this was just hearing number 1. So you get 2 more opportunities there. I do have a question for the sponsor. I think to get at Mr. Oliver's questions, I'm trying to get, and I was reading through Mr. Gugelman's 20-page memo. I want to get a kind of better feel on the amount of time you think it might take to get that recall process, because as you know, there's enough signatures. Then the person who's under the recall is in a situation where they can write a comment, and then once those are completed, then you have another 30 days to get to 15%. And the reason why I asked, I'm just trying to, again, gauge the financial impact and the pragmatic impact. How long do you think that might take? And the reason why is, could this, if the voters approve this recall election, which I happen to think they might, would you just not make the recall election the next scheduled general election? Because of that time frame. But if we have, of course, special elections. I was elected by special election because of the Senate back in the day, because of the passing of Howard Futch. But I'm just trying to understand what you think the timeline would be. Would it be 90 days? Would it be 120 days? Just the threat of a recall, I know as a former elected, would be a very big strain and maybe change my opinion on some things. But give me a feel for that. I think that would help the discussion as we go forward, so we can tailor this proposal in a way that I think might work. So if you could take a shot at that, and then maybe Mr. Oliver does as well.
I added it up to 160 to 190 days from beginning to end.
Okay.
And Mr. Chase, did you coordinate with the supervisor of elections on the timeline it would take to conduct a special election? The reason I ask is I've worked with her through a number of elections, and there's often a lot of work that goes on before Election Day. I mean, it can be 3, 4, 5 months of work to get the ballots prepared, printed, mailed on timely manner to meet the Florida statutes, especially as they continue to evolve over the last couple legislative sessions. So I would, ask all of us, or maybe the city attorney, to ask her, how long that time frame is that she would need the ballot to be on a special election. What's her time frame? And then again, I would really want to know what the cost of one of these elections is, just so the county is aware of the cost of such an election, should we decide to incur that cost.
What I could answer is that this proposal would require the supervisor elections to do nothing that the supervisor elections isn't already required to do, because it was patterned after state law for the recall of county commissioners and city commissioners. So the time frames are in state law. If there had ever been a recall prior to today of a county commissioner or city commissioner in Brevard County, the supervisor of elections has to comply with it. So no, I did not work with. There was no reason to. It's set in law.
Mr. Fisher.
Paul, I saw a memo from, I think, legal counsel of the school board that was making reference to statute 1001.32 as whether or not we as a county had control over the school board matters, and whether we could recall them or even put this in place. Are you aware, have you had any conversations with the school board council that might have?
I know the school board council, but I don't know, I don't know what their position would be with regard to this. I really don't. And as indicated in my memorandum, I think the key thing that I leaned on was the Attorney General opinion.
Okay. Yeah, he makes reference in statute 1001.32 governing the governing and the management, control, and operation, administration, and supervision of the district school board system, and counties are not given any authority in this scheme whatsoever, and that we have no authority. And under Chapter 1001, State Board of Education is really in charge of this issue and determine the laws and rules.
I think that that's generally true, and as going back to that Attorney General opinion from 1971, that's kind of the theory under which that they were operating, and the theory basically is that counties are dealt with, counties and cities are dealt with under a totally different article of the Constitution than schools, and it's just like two different worlds, if you will.
Okay. Other questions on this issue? One final one, Mr. Gugelman. I should know this, but is it required that a school board member gets a 4-year term? Is it possible for us to say that a part of this Charter Review Commission to say that our school board members would be under a 2-year term instead of a 4-year term?
Again, haven't researched that question, but I think the law requires 4-year terms, I believe.
That's okay. I think that's the case too, but if you wouldn't mind finding out for sure, that
we'll
might be
check
helpful.
it.
All right. I'm sorry. Dave, Mr. Newman.
I also want to ask Mr. Gugelman on the speech issue, since that came up on here. Would you know if this body or the county can actually talk about public comment versus the non-agenda item versus the agenda item? Like, I believe it was no less than 3 individuals had talked about that today. Are we able to make a proposal that would be constitutional for that?
What kind of proposal would it?
That non-agenda items would be treated in the same manner as agenda items when it comes to speaking and being, I guess, seen at the meeting, because I guess at one point they turned off the camera for those folks too.
For a county or for a
for the school board?
For the school board.
Yep.
Well, I think probably not.
Okay.
And the reason that I say that is that I think Mr. Tredis has pointed out in his proposal to repeal the provision in the charter regarding single-member districts.
Okay.
I think basically, I think there's great question as to whether or not the county, through its charter, could enforce regulations against the school board.
Okay. Thank you.
Mr. Chair, I just have a quick question. Since we're talking about the recall and the fact that could, if enacted, lead to a special election for a school board member, I think it's applicable to look at what just happened in Palm Bay, because they literally just had a special election. They had a council member that resigned in August and ended up holding a special election in March. It's a pretty tight time frame. Obviously, a recall process is different because you have to have time for petitions and things, but that puts some kind of time frame on it. I know when they discussed it, they estimated that it would cost them, and I don't know what it ended up costing them, but they did estimate that it would cost $245,000 to run their special election. So that's as Palm Bay is our largest city, it's not the size of an entire school board district, but that's a point of reference for us as well. Something we can just kind of look at as we're talking about the cost that this would have.
Good point. All right, we are on item number 3, full-time commissioner. Ms. Sullivan, you are, I think, the person who sent this in to us. Why don't you take 3 minutes, if you don't mind, kind of presenting your idea, and then from there we will ask questions if necessary. If not, we'll move on to number 4, the citizen process.
Sandra Sullivan. It's not so much that they're a full-time commissioner. It is that they don't have a full-time position in addition to being a commissioner. And the reason for this is having attended meetings for 3 years, and I look at some of the decision making and analyzing why did things happen the way they did. So let me give you an example. The topic that has been discussed more than any other topic over the last 3 years is that of solid waste, running out of space at Sarno dump. So this conversation has had a lot of meetings, and we got to May of 2021, and we're going to run out of dump space this summer. And then they authorized the construction of a new site out at 192. And then 9 months goes by, we have the budget review meeting recently, and it's like, how are we going to pay for this? We need a study. 9 months after we're starting construction. So it's crisis management. So in some of the comments that have been made over time, at one Brevard commissioner meeting, it was stated that 3 of our commissioners do not do regular staff briefings. I was pretty shocked by that. Looking at some of the meetings I attend, there are a number of commissioners who do not regularly attend the boards that they are assigned to attend. When you have a commissioner who has a business on the side, or say consults, or is a realtor, or some job that gives him flexibility, then he can meet the demands of what the county needs. But when you have a commissioner who has full-time employment, they don't necessarily have the time. We're a growing county. Our budget is $1.8 billion, and we're growing very quickly. I think with the growth of the county, we have to consider making changes. I think what we need right now, we need people on our commission who have the ability to have the flexibility to give the commission the time it needs to perform their duties. And I think this relates directly back to the discussion, too, that you're having about remuneration for those commissioners. And if there's a commitment, at least that they do not have another full-time commitment, I think the taxpayers might be more amenable to considering an increase in their remuneration. But otherwise, I think you have a hard time with that. And we are going into an inflationary period, so I think there'll be some objections to that anyway. But that's getting off base. But I just wanted to communicate the reasons. I attend those commission meetings, I think, more than any other citizen of Brevard County, other than the staff members and the commissions themselves. Is there any questions?
Thank you, Ms. Sullivan. Any questions? Yes, I do.
Ms. Sullivan, so you're okay with part-time? I just want to make sure I'm following.
Absolutely.
Okay.
It's very reasonable for them to have other interests.
And then with that being said, are you setting a time limit on that of maybe 20 hours or 30 hours? I mean, what's your thought?
No definition on that, because the general intent is that they give being a commission board member, that they give it the time that it necessitates and adjust their schedule accordingly to meet their commitments.
Okay. And if this proposal were passed, would you be a proponent for an increase in wages, considering the fact that they can't have another larger income on the side?
Considering I'm running, that's a tough question. Here's my general feeling, just stepping aside as a candidate. If you want to attract really good people, okay, you want to pay a fair compensation. Otherwise, you're going to get, we have candidates running that don't have a business background or management background, or even have served on boards, whatnot. You want to attract good candidates that have the experience that you like to see. Essentially, it is like, in many respects, running a business, and some, from the monetary and understanding profit and loss and balance sheets and the financial side of it, having the experience. I mean, if I was to go out in the private sector and have a job, I'd be over 6 digits. I'm not pursuing and didn't know that this was even going to be covered. Monetarily, the pay is not what is motivating me. It is the issues I'm concerned with. But not everybody, while I have the luxury to be able to accept and live on a lower pay, there's some people that, that have commitments and mortgages and whatnot that they need to meet. So, it does eliminate, it limits it more to the people who have monetary resources to run. So there are pros and cons. I have no energy one way or the other. I'd be happy with the 58. I'm just speaking that, just hypothetically, I think it would be, for the voters' end of it, it would be more palatable to them if they knew that they were getting somebody who was not just looking at this as a part-time endeavor.
Well, thank you for your response.
Thank you.
And your insight on that. But it sounds to me like you couldn't quite say one way or the other. Is that
you're marking out as undecided on that one?
You're getting the political or the experience in. I'll put it that way.
Let me put it to you this way. I have invested as a volunteer over 3 years of attending county commissioner meetings on a very regular basis. Obviously, money doesn't drive me.
Right.
That has been volunteering to my community. So, this wasn't even on the table when I put my name in to run. So I don't have any energy. From the perspective, would it be nice to be paid more? Absolutely. Who wouldn't say that? So, but I'm here to my commitment to the community, and I love Brevard, and I want to make it better. And then that gets into I sound political, but that's the truth. I've been doing this already for 3 years as a volunteer.
Thank you, ma'am.
So, yeah.
Question?
Yes, I have a quick question. Sandra, let me ask you this. So let's say somebody's running for county commission. You talked about the need for experience, business experience, all that life experience. Are they supposed to now give up that full-time business or job because they're a county commissioner? How does that impact their ability to do what and a lot of people would say is a thankless job because they get their teeth kicked in all the time by the public? Why would you want to say you can't have a full-time job? I'm not following.
Because the county is getting to a size. We're talking about we now have a $1.8 billion budget. We have a very much growing county, and I've talked to some of the commissioners. They go, I don't even have time to read the details on the agenda. If they don't have time because they have a full-time endeavor to attend the boards, for example, TPO, that's a required board to sit on, but I go to those meetings, and very often there might be one commissioner there, or maybe two, and there's that knowledge is important to the decision making that they make up on the dais. The other boards that they sit on, the staff briefings are very important. So in one county commissioner meeting, as I said, it was stated on the dais that 3 county commissioners do not regularly attend staff briefings. That knowledge by the staff who are in the day-to-day affairs, that's like being like a manager of a company and saying you're not going to listen to your heads of your department because you don't have time because you have another full-time job. All I'm just saying is they can have jobs outside of being a commissioner just as long as it's not a full-time position. So there's a lot of flexibility, I think, with that to find other opportunities, just not on a full-time basis.
Thank you. All right, thank you.
Mr. Chairman, I do have one quick one, Ms. Sullivan,
Sure.
Before you go.
Mr.
This
Moore,
is a popular
question.
one today, and I will put on the record, and I think Sue and Marcia will chuckle when I say this. Many moons ago, when I ran for the county commission, this was a pretty hot issue. I think the piece of mail said from my opponent, someone with a lovely wife, 2 beautiful kids, and a full-time practice surely doesn't have time for you, right? I think was the way the mail read at that time. And Gabriel and Vic actually asked 2 of the 3 questions. One, what constitutes full-time? 2, how do you feel about the compensation? But number 3, kind of going back to Vic's point, and I certainly, for my own personal protection, am not suggesting that you are correct in saying that commissioners are not adequately informed, don't attend board meetings, don't attend staff briefings, and not talking with constituents. But will full-time fix that? I could argue to you that potentially people who don't have full-time employment could still fall into the category of those 4 things that you've alluded. How will not having a full-time job remedy what you've pointed out as being the concerns?
Well, when you look at the commissioners who potentially have those full-time jobs, and you look at perhaps them having that issue more than others, of course, there's one commissioner who's not working full-time that is not attending staff briefings, so that certainly could be the case. But if, as the position that we're in right now with the size of our commission, at least if we start from the starting place, that there's an expectation that you don't have a full-time job. And I would say that would be defined as if you own your own practice, you have the ability to hire other people to come in and do the functions that you're doing. That's not what I'm talking about, because that's not a full-time job. I'm talking about employment with somebody where you have a position of, I guess, 40 hours a week is considered a full-time position. So, you have a position that requires that amount of hours a week, then you don't have that time to put into the county commission because your commitment is to another entity. Whereas if you own your own practice, that's up to you to, figure out how you're going to manage that. So that, I guess that would be the distinction. Being the business owner is different than being a commitment to another entity for that time.
Got it. Yep. Thank you, Ms. Sullivan. Thank you, Mr. Chairman.
All right. Want to speak on this?
Well, since I'm the only one up here that was one of those, beside this one, I would like to address that. And to me, the answer is there are a lot of people that are here, and I would have to agree that less government is better government right now today. We see that in a lot of other areas. And a commissioner has the right, if they want to be there full-time, fine. If they don't want to be there full-time, and they do not have to attend briefings. In fact, I would say that if you do your homework and you read what the agendas are, you will then know what you should be doing or have an opinion on. And the staff, believe it or not, does have other things to do, like roads and parks and scats and all kinds of things. So I would say that having a full-time commissioner, if you want to be a full-time commissioner, you certainly can. It's your option. But commissioners are not just in that office 8 hours a day. They just aren't. You're working, if you do the job properly, you are out doing things on Saturdays, Sundays, evenings, and it is truly beyond a full-time job, even if you have another job. And I would just recommend that if you haven't been there, you don't know.
All right, we have one additional speaker on this item. It's Karen Colby.
Hi. Karen Colby, Beachside, Indian Harbor Beach. I'd like to talk about the full-time versus part-time on the county commission. When we elect a person to the position, I don't remember having any requirements based upon their hours that they're allowed to work outside of their potential elected position. This would lead down a slippery slope of people wanting to come and apply to run for this position, potentially not get it, and then be able to sue because you made them give up their business, their real estate company, their catering business, their bar. I mean, I'm not a business person. I am not an academic. I was just a regular hourly employee. I want people that work full-time. I want people that have jobs. I want people who know what's going on in the world. I want people who are paying $4 for gas. I don't want somebody who's come from another country who gets maybe other funding that can afford to live here that I don't get to have the say-so on whether I can have my commissioner up there 20 hours a week, 40 hours a week, or 120. It doesn't matter. I didn't elect him, her, she, them, they, it, whatever, to work a set schedule. I want them at the meetings unless there's a personal opinion, a personal issue, or if they're sick. But I don't think that we should require anybody to put in 40 hours a week on the clock or not run. I mean, we would be limiting ourselves for the most talented people in this county. We have the people here with the most experience that have gained the instruction to make their own companies. We are listening to a person from another country who is also a dual resident who wanted a $120,000 a year job from the county commission to work full-time as a consultant and got told no. Now they're running for office. I apologize to anybody I offended that, but that's the truth of the statement. And I support our current county commissioners, all of them. Thank you. Any questions? I'm sorry.
Seeing none, thank you so much.
Thank you.
Mr. Gugelman.
Yes, Mr. Chairman, just going back to the item on school board terms, I did check it, and state statute does require 4-year terms.
Okay, thought so. Thank you. All right, on that item 3, we're concluding that, so we have completed now hearing 1 on item 3. We're now on item number 4. It is also by Mrs. Sullivan. Ms. Sullivan, why don't you take 3 minutes to present that for us, and we'll go from there.
Good afternoon again, Sandra Sullivan. So in attending these meetings, so I'll tell us a story. So I was a mom, 3 kids, taking care of my kids, my organic garden, life was bliss. I pinched myself every day when I got up, live in a beautiful place. And I find out I live on top that there's a lot of cancer in my community. And I think most people know me as that lady that dug up all the stuff in her backyard, did all that research to help get the formerly used defense site. One of the first places I went to was our county commissioners for help. And unfortunately, did not get the help I needed. I tried to get items on an agenda and was not able to get items on the agenda. There's really no process that I can find to bring an issue that is of importance to a community and have a citizen-driven process to putting something on an agenda. If a commissioner doesn't want to meet with you and talk to you about something, doesn't have to. Just be clear on that last item, just as a side chat. I wasn't saying that a commissioner had to spend X number of hours in the office. It's not about a commissioner being full-time. It was about not having full-time commitment. But on this, the way it works right now, which is not really clearly defined in the charter, is there's something called Speak Up Brevard. And once a year in December, this form is open on the county website. But most people don't know about it, even me who attend so many meetings, because it's not written in the charter that this is Speak Out Brevard where you go to and put in a proposal to bring it to the county commission. So there's a disconnect there. There's no way to know how that process works. And I sent emails to my commissioner and did not get a response back on how that process works. But December is a bad month for people. I got 3 kids. I'm buying, preparing for Christmas and gifts, and you got school kids coming off of school. And I tried to fill that form out. I had so many commitments in December. It's a hard month. And then I went, I'll do it December 31st. I'll do it after 5 o'clock. I get sat down on my computer. It's closed. It closed at 5 o'clock, not at midnight. It closed. And the last minute I was going to push it out there. It was closed. It was gone at 5 o'clock. It said, see you next year. So if that process is just a form, it's not going to cost the county more money. If that form was available at any time with some, criteria to even put it on there, like you have to have so many petitions or supporters or whatever, but just some criteria that the public can bring something to the commission. Thank you.
All right, any questions? All right, seeing no questions, we're going to go to item number 5. Mr. Tredis, I believe this is your proposal. Why don't we go ahead and present that, please?
Okay. This is a proposal to repeal from the panel of 3 attorneys who review charter amendment proposals by citizen petition and by charter review commission. What is in the charter now is if either by petition or the charter review commission, a proposal passes the commission or gets enough signatures during the petition process, it then is forwarded to the Board of County Commissioners, who then are, pursuant to the charter, are responsible for hiring 3 attorneys or retired judges, a combination thereof, to review the proposed amendment, to opine, like Mr. Googleman has been asked to, through a memorandum already, whether a proposal is not inconsistent with state law or special local law approved by the voters. And the difficulty, the problem, objection I have to this part of the charter, first of all, there is no other provision like this in any other charter in the county charter in the state of Florida. This is only one of its type. It's unique to Brevard County. But the objection to it is, first of all, conflict of interest. The Board of County Commissioners get to decide who to hire as these attorneys. So the county commissioners will be able to hire attorneys who will very likely decide the matter, or could decide the matter, be influenced to decide the matter in the manner that the county commission would like them to decide. For example, in my charter cap amendment proposal, at least 4 out of the 5 county commissioners, I'm certain, are against that proposal. Yet those county commissioners would decide which lawyers to hire to opine on its, whether it's consistent with Florida law or not. So there's a conflict of interest that is there. And then secondly, the way the wording is in the 3-attorney panel is that the county commission could actually, I think, have complete decision-making whether or not in their view, the proposal goes to the voters, because if at least two out of the 3 attorneys opine that it is not inconsistent with Florida general law or special law, then it shall go to the voters. However, there is case law, which I'm sure the county commissioners know about, or the county attorney will advise them of, which holds that the word shall in certain circumstances can mean may be discretionary. And the county commissioners would be able to rely on that case law and perhaps the county attorney's opinion to say, well, it's up to you. Even though it says shall, you can interpret it to be may, and it's your decision whether to send it to the voters. On the other hand, the charter doesn't say that if only one of the attorneys says that it's not inconsistent with general law. It does not say that it does not go to, the proposal does not go to the voters, but it's only an inference there. There's no specific language that says that. And and the county commissioners can say, well, it's only an inference, so we only got 1 vote. We want it to go to the voters because we think it might pass, so they could take that position. So, in my opinion, it's a conflict of interest to have this. Brevard County is the only county charter that contains this provision. It's subject to, abuse, I believe, and to me, it's really it's government by a 3-panel group of lawyers, not government by the people. We have Mr. Googleman to answer the same question that this 3-attorney panel would be asked to opine on. We have Mr. Googleman to ask. I don't think the attorney's opinion would be that much different unless there were that conflict of interest. But I also would point out that, what if we wanted to hire 2 or 3 more lawyers instead of if we just wanted to hire 2 or 3 more lawyers to get opinions like Mr. Googleman has provided? Well, in Charter Provision 2.9.3.1, excuse me, that's not the right one. In the very beginning, the charter says that the Charter Commission shall be funded by the Board of County Commissioners. So I think we have the authority to hire our own lawyers if we wanted to. So I think this is a really undemocratic procedure that we have in the Brevard County Charter. I don't see any usefulness for it. I think it could be subject to abuse, and that's why I filed my proposal to repeal it.
Thank you. One question I have, you'd mentioned in your comments that we're the only county that has this 3-judge provision. Has it ever been challenged in the courts?
It could only be challenged here because we're the only one that have it, and it has not.
Is that accurate, Mr. Gogan?
I don't know.
Okay. I think that's, as mentioned, no other county has it. What would be the procedure for us to challenge that ahead of time if we chose to?
Challenge the provision in the charter? You'd probably need to get some sort of a declaratory ruling from a court, but I'm not even sure if you'd have standing to do that. So. Because
you're in the catch-22 here, right? We passed this, the 3-judge panel says, and you're out of business. So I think we might want to explore if this is an idea that the commission, our group wants to look at more closely. Clearly, there'd have to be some type of challenge. We'd like to know who would give that legal standing. Would it just be a citizen of Brevard County? Would it be this group of folks assembled today? Because if we're the only county in the state that has it, if this is a consideration we want to take up, I think that definitive answer needs to be given, or we're just wasting our time.
I might suggest that be delayed until there's actually a proposal that's approved by the Charter Commission that the County Commission says we're not going to send it to the voters, even though 2 out of 3 of the lawyers got it. I understand that my proposal is prospective only, and it changes it in the future. I understand that. But to me, it would just sort of be like a lot of waste of time and money to challenge something that we might not even need to challenge, because for all I know, maybe no proposals will even pass here. So
yeah, again, it's a catch-22. That's what I think that is a serious proposal. I mean, to me, that this does stymie the whole reason why we're here potentially, where two lawyers can decide all our time we put in was worthless. So if we could just explore that, Mr. Gogelman, that might not be a bad idea, just to understand if we have that option, because I don't want to spend my summer doing this and then just have two lawyers tell me, never mind.
Okay, so I get the thrust of where you're going correctly. If you could repeat that.
What I'd like to see is in your opinion, how would you challenge this provision in our charter without having to go through the process we're potentially going through? Because if our goal is, as we're citizens of the county, 2/3 or half, whatever we decide to do, 8 or 10, think it's a good idea, and then two lawyers say otherwise, they can do that to not just one item that they might not like, but the entire thing to make this whole group irrelevant. And I don't think that's the intention of the voters. That's why they voted for this many years ago. Mr. Jenkins?
You might remember one of the law firms that we interviewed commented about their experience in Orange County, where the county commission did not put something on, and the Charter Review Commission actually took the county commission to court, and I think they prevailed. I'm not sure.
Yeah, I'd like to look into the history, Mr. Gogelman, to see if that's the kind of case we have. If that's okay with everyone else. Is that okay? Great. That's it.
Mr. Chairman, I do have one question on that topic. Paul, let me ask you a question based not on the legal side, but you've served on this committee before. Were you there previously when this three-panel group of attorneys was added?
I don't recall, to be honest with you. I don't think I was. I served on the original Charter Commission, and I served on Charter Review Commission as well, much as this body. And I don't think that this proposal had been put into effect at that point.
Okay. So, Mr. Chairman, I'd also be interested in the history. When did it come about? When, how, and the like. And then the last question, Mr. Tredis, on your concern about the county commission having the choice. If let's assume, for the basis of my question, that the three-attorney panel had merit, I've at least heard it stated before that making those decisions rather than going to the single attorney, you get the three-panel assessing, like you said, legality, constitutionality, and the like for the threshold to get on the ballot. Let's assume that that was something that was important. When it was at least argued to me when I was here the last time, that's a faux pas, if handled incorrectly, could be of magnanimous cost if you took forward something that ultimately had some constitutional or legal challenges. But let's assume for a second that it is a viable thing to do, because conflict is your concern. Would you feel better if this body was the choice for those three attorneys? If that process actually had merit, would that resolve your concern relative to conflict?
Well, I think we already have that ability to hire additional lawyers. That's, I think, answers the question. If we want more than Mr. Gogelman's opinion, then I think we can hire other lawyers ourselves. Like in the example of this recall petition, a close call. I don't personally think that any other experienced good lawyer would come to any different conclusion. The court could go either way on that, I think. I'll make certainly an argument that it is consistent with general law, and I can put that in writing. But I think we have the ability to hire additional lawyers if we want to. So I don't think the charter needs to be changed in any way. This just needs to be repealed, in my opinion.
But I mean, I was asking very specific to the conflict issue, because I mean, you raised a concern that the people who actually choose them could make a choice that impacts the opinion based upon who's paying the bill and who they represent. And so that was my question. So you would still feel the same way? You'd like to see the lawyers go, whether it's chosen by this body or the county commission?
Yes, because like I said, we can already hire more lawyers if we'd like.
Okay. Thank you, Mr. Chairman.
Thank you. Are there any other comments on item number 5? That now that it's completed its first hearing, Mr. Gogelman, you got some more homework? So
I do.
And if the staff could work on the history on that side, might save us some money too. All right.
I had a carbon.
I'm sorry?
I put a card.
Oh, I'm sorry. Ms. Sullivan, come on up. Let me give you a comment on that. Welcome back.
Yeah, Sandra Sullivan. So just as an example of a potential conflict of interest, I've talked to some staff, and they would like to see the charter cap removed for the reasons I discussed earlier. So in talking to other counties about what they have in their charter, I would like to give an example to compare and contrast. I spoke to Sarasota County, and they actually took it a step further than they don't have the 3 attorney, but their charter review is not appointed by the commission, by the county commissioners. They are elected. And I thought that was an interesting concept. I just wanted to put it out there because just, reinforcing this is a body who reflects to bring the will of the people to allow the voters to have an opportunity to vote on things that are important to them. And so I thought it was kind of interesting just to compare and contrast what Sarasota is doing. Thank you.
Thank you. All right, so we've completed the 5 items that were placed before us. I also want to bring to everyone's attention, we've received a couple of more proposals that would not be considered reading number 1, but what we've done in the past, maybe to our dismay, is we brought these issues up so that people can quickly present them. But what I believe the sponsor of the first one, which is Michael Myjack, is he here? Michael, come on up if you don't mind. We'll give you 3 minutes, much like we did everyone else, and we'll do the same, Blaze, for yours as well that's been introduced. We're not going to have a big comment on it, but at least to introduce the ideas so when we do our reading between this meeting and the next, people have a better concept of what they're going to be handling in the, quote, first reading. So, Mr. Myjack, thanks so much for being here and taking the time to put forth your proposal.
Get this off. My name is Michael Myjack, and I represent myself and my colleagues on the Indian River Lagoon Roundtable. That's IRLroundtable.org. We're an organization of nonpartisan, non-affiliated, grassroots people that explore environmental issues that have significant adverse effects on our Indian River Lagoon estuary. Today we're here to propose the right to clean water, a charter amendment, out of shared desire to save the Indian River Lagoon, a natural wonder which in years past has had much income to our area. Our Florida Constitution charges the citizens of Brevard County with the power and responsibility to protect our residents, businesses, visitors, and economy from legalized harm. Can you imagine water, source of our life on Earth, having no such protections? The right to clean water must be spelled out in our charter for the benefit of all and to protect us all from harm if we are to have a legal basis for a right to clean water. The right to clean water unifies and amplifies the voices of all citizens. The right to clean water is a home rule issue. Declaring the right to clean water, we, the people of Brevard County, ensure legal accountability will be added to our state's water protection efforts. When Florida fails to protect our waters and environment, it's up to local jurisdictions to step up and protect our communities. While we may have mastered the process of permitting, we have yet to ponder the processes of preservation, protection, enhancements, and restoration with equal intensity. Please don't make the mistake that the late Indian jurist Sri Palkavala warned against when he said that Dharma lives in the hearts and the public men. When it dies there, no constitution, no amendment can save it. With the Right to Clean Water Amendment, our grandchildren may one day reap the rewards of the seeds that we sow. Once again, we may see our waters teeming with fish and wildlife. Once again. A draft amendment has been provided to you in your packet. It's loaded with options that can be considered and customized any way you see fit. As you review and discuss the proposed charter amendment for Brevard County, consider our lagoon and our waters, our estuary. The right to clean water. One sentence. Because our waters should flow, exist in their natural form, be free of pollution, and maintain a healthy ecosystem to provide a prosperous habitat for generations to come. Thank you.
Thank you, sir. We'll be taking that issue up next meeting. We look forward to seeing you then. All right, Mr. Tredis, we have one more item, yours. It would be number 7, I believe, in our potential items. And if you could take that up, that'd be great.
I have filed a proposal to repeal Article 8 School Board of Brevard County and Section 8.1 Election of School Board Members from the Brevard County Charter. This idea came to me actually at the last meeting when Mr. Gugelman, to my impression, was expressing some doubt on the sort of the lawfulness of Article 8 in the Brevard County Charter. So I did some research after that, and what I found is that this became a part of the charter in 1998 when the voters voted for it by 58%, the single-member election district by residence area. But I looked at some statutes, and my position is that this charter amendment was contrary to law, both when it was adopted in 1998 and it is today contrary to law, because the statutes have been renumbered over the years, but both in 1998 and in today, the statutes say that single-member voting districts by residence area for school board members can only be created by 2 ways. First of all, the school board can pass a resolution, and then it goes to the voters for a vote. Secondly, there's a petition process where I think it's like 10% of the electorate can sign petitions, and it goes to the voters. But there is not in Florida law any ability to create single-member school board district elections by charter amendment. And I don't think it's, I think it's been contrary to law all these years. And I think that, I guess fortunate that there haven't been any legal challenges, but I think that the problem with it still being in the charter is it really subjects our school board elections to legal challenge by probably a losing candidate or someone who really doesn't like the winning candidate. And that can be done. I believe it's called a petition for writ of quo warranto is the technical term for the challenge. And I think that school board elections in Brevard County are really vulnerable. This type of what could very well be and may be a successful legal challenge. I believe that this uncertainty and I think likely contrary to law of Article 8 should be remedied by its repeal. It's very easy if the school board thinks otherwise and they want to get this into the charter, all they can do is vote for it, and it's on the ballot. The petition process is always very difficult, but all it takes is a school board vote to put this on the ballot if they want to do that. But I think in the memo, the 20-page memo that Attorney Gugelman submitted, he addresses this in 2 different places, in which is, I think I've included in my proposal, I think, which is that Mr. Gugelman also was, I think, of the opinion that this was done contrary to Florida statute when it was done. And then on a final note, I personally favor of district-wide election of school board members in which every elector through the county gets to vote in every school board district race. I personally don't know why anyone would oppose that, because the voter gets to vote on every candidate of the school board, and by state law, every school board member represents the entire district, not their residence area. That is in state law. So, you know, if a candidate says, well, we want single-member districts because we can focus on our schools, my schools, I've heard them actually call it, it's not their schools. They represent the entire district. And what this district-wide school board elections would do would allow the voters to vote in every race and really control the composition of the school board So that's why I'm in favor personally. But that's beside the legal argument, which is just it was done contrary to law. That's all.
All right, we'll take that up in our next meeting. Thank you so much. Oh, anybody else? Okay. All right, we are now in section G, which is revision of future meeting schedule. Does everyone have their meeting schedules in front of them? Of course, today's the 24th of March. Our next scheduled meeting is on the 7th of April. And I think the question I have is, when do we want to take up the actual final vote after the 3 hearings have been held? Do we want to do this on one day at the end of our schedule, or would we like to take it up at the meeting following the 3 hearing dates? Mr. Tredis.
My preference is to not wait until the end, but to take each one up as they come up, they're ready for a vote. And there's a reason why, especially in the recall of school board election proposal, and that is that I believe to try to get an attorney general opinion to weigh in on the matter, I think that needs to be done before that can be pursued. So that's like a real reason why it should be done in that case. And, also putting all at one at the end, I don't know what everyone's schedule will be, but maybe that'll be in the summer when a lot of people are on vacation. Just like I think a lot of people likely to miss one meeting at the end. So I would prefer that they be voted on as they're ready to be voted on after 3 public comments.
Mr. Chair, I'd agree. I think the potential is there. If we try to do it all in one big super vote, we may end up opening up Pandora's box for all the discussions to go round and round all over again as well.
Okay. Other opinions? Anyone have a counter opinion to that? All right, so with that said, let's just be clear on the things. For example, on one of our items that has already had now 2 meetings, we would have the third.
Mr. Chairman, I apologize. I did just think of one. I don't have a counter to Mr. Tredis, but we do have 2 pending issues that are going to resolve how many votes it's going to take, which has to be resolved before you're going to vote on any issue. So we may get to that meeting after the 3rd hearing before we fully resolve the 8 versus 10 one, the 2 outstanding procedural issues that came up this morning. So not opposed to what Mr. Tredis and Lubker have stated, but we certainly can't get there without resolving the other 2 outstanding procedural issues.
No, I couldn't agree more. And our next meeting is scheduled for the 7th of April. And I would hope that our legal team would give us some information before that meeting. I mean, we've got approximately 2 weeks for that. So I anticipate that coming before us. But that said, again, I'm in no rush to vote. What we can do, if you wish, is maybe we schedule the meeting or the vote, I should say, whether it be 8 or 10, on the 12th of May for our first item, or any items that are eligible on that date. Would that work for everyone? Okay. So let's put that into the 12th of May. We will vote, of course, making sure we have our other issues kind of settled. So we would have that vote on the 12th of May on the school board issue. And that would be, and then technically, if we are moving forward, there's a chance that the others could also be voted on that day if the things fall in line. Other thing I wanted to talk about is I know for a fact I will not be here on the 7th of April. And I will not be here on the 2nd or the 30th of June. So, and it sounds like each of our votes might be important on a lot of these dates. So one is letting that be known. I am happy to turn over the reins as chair to Mr. Moore. But if we want to adjust dates, I'm also open to that, or add dates, whatever we would like to do. It's something, again, maybe we start sending in dates that are availability to our team this week, and so we can find some dates that for sure work, so that we can have additional meetings. And if not, it just might mean we have a crowded schedule as we get into July and August. So put those dates into the staff. We'll see if we can't find a date that works for hopefully everyone, because I think the votes will really matter.
But I guess the first pending question is, I won't be here on the 7th of April. What's the will as far as having the vote, should we get the information from Mr. Googleman on the 8 versus 10? I'm not sure if other people are going to miss the meeting on the 7th of April either.
I'd also have a conflict on the 7th and 8th of April.
Okay. So we're down to 13. Okay.
Could we just do it on the 21st, the next meeting, April 21, instead of the 7th?
Meaning the vote on the 8 versus 10?
Yes.
I think that works. Is everyone still good for the 21st of April so we can have the vote on that date? Plus, we'll have plenty of information by that point as well. Do we want to have a meeting on the 7th of April to get those meetings in place? No. Okay, so let's cancel the 7th of April meeting.
Thanks.
And then as far as the 2nd and 30th of June, as point, let's just put those in question, and the staff will get the requests, or at least information from the committee members as far as their availability in, I can literally say I'm gone almost the entire month of June. So hopefully either late May or early July might be a meeting date that works, because we have a pretty big gap there between the 30th of June and the 21st of July. But again, just send in dates as best you can, and obviously on some of these important votes, we want to make sure we have everyone, or at least close to everyone, for those bigger votes. All right. Any other questions on that scheduling issue? Okay. All right. The fiscal analysis direction. Do we have anything lingering there, Jim?
Yeah. Thanks, Mr. Chair. As we discussed before, the charter requires a fiscal analysis of any amendments that are passed. There's staff's recommended two different methods. We could go out for procurement for a firm similar to the attorneys, or we can use our internal accounting auditing contract with RSM. Their fee is $200 to $275 an hour. We also have an external auditing contract with Cherry Bechtel. There is no standard task order in there. And then we also have our financial advisor contract with PFM Financial Advisors, and their charge is $175 to $200 an hour for the task orders. So we're looking for directions on how the board would like us to attain somebody to conduct the financial analysis for you.
I guess I put it at 2 points. Do we want to make that request once we actually think that these, once they're actually voted on, and or do we want to get that fiscal analysis before we have our final vote? I mean, it's an obvious answer, but I'm open to that.
I mean, I'd prefer to know what the fiscal impact of what we're voting on is before we vote on the final vote, but that's just my opinion.
I agree. And then the second part, of course, is who would do the work? Anybody have a preference? You want to leave that to staff?
I would defer to staff on that.
Anybody have an objection to that? Okay, let's defer to staff. Whoever you all feel most comfortable with, feel free to use.
Yes, sir.
All right, we have temporarily passed for next time, I'm sorry, till the 21st of April, I guess it is next time, the motion to change from 10 to 8 on Rule 17. And we're also going to, we have tabled a new business, which is the motion to delete Rule 16 in dealing with at least one member appointed by each commissioner being present. So we'll refer that to April the 21st as well. And I believe, Mr. Tredis, you had one more item on referring an item to our Attorney General, Ashley Moody.
I will not make that motion today.
Okay. All right, we have a couple people who'd like to make public comments. We'll allocate, like we've done all day, a couple minutes to each. We have first from Vieira Robert Burns. You're recognized for 2 minutes. Welcome, Mr. Burns.
Hi, Mr. Chairman. I'm sorry I'm late. I had a few agenda items I wanted to address, but I was helping someone look for a chair, so I was caught up. The first item I wanted to talk about was this full-time commissioner. I don't think anyone running for office ever ran and said, hey, I'm going to work 20 hours. And I don't think any commissioner that you would ask right now is going to say that they only work 20 hours. However, the commissioner from District 2 made a change, or proposed a change that was passed to the public records. And the way that they calculate public records costs is based off of not 40 hours per week, but 20 hours a week, which is essentially double the cost of public records requests. Because that commissioner at the time argued that the position is a part-time job. So that has, like I said, increased the cost of public records by 100% at least, because they also use their benefits as part of the calculation as well. I think that has led to further obstruction of our transparency for public records, and it makes me want to bring forth a proposal that maybe that's something that can be addressed in the charter, as far as instead of just a board policy or an administrative order on the cost of public records. I'm running out of time. The other things was in regards to the recall election. We just had a long legislative session, and not one of our representatives from our Brevard delegation brought this up, and I think that they would have had the support had they brought it up. We do have a special session coming up, I believe, potentially for the homeowners insurance. I would solicit that our delegation try to bring forward that issue, and then we won't have to even worry about it as far as the charter is concerned. However, I think that what we're proposing at our charter level is going to make the same mistake that we think that the state has made. There's several offices in Brevard County that cannot be recalled. Public defender is one of them, state attorney, sheriff, property appraiser, tax collector. So there's a lot of elected officials that cannot be recalled currently the way it sits. So instead of just saying we should only have school board members, we should just say any elected official in Brevard County should be able to be recalled under the same guidance and statutes that we currently have for commissions and city council. Okay. So that would be how I would like to see it go forward, instead of just saying, school board, anybody.
Okay, great. And as you know, in the next meeting, which is now the 21st of April, we invite you to testify again. That'd be great.
Sure. Thank you.
Thank you so much. All right, we have Katie Delaney also on public comments. Welcome back.
I just wanted to comment on some of the things that were spoken about today. I have personally been to every school board meeting and every workshop since March of last year. So I was right there in all the mess that was spoken about. Never once did I feel in jeopardy of my safety. But what I did feel was that we were being totally disrespected as taxpayers and as parents. These are our children. They are not wards of the state. They are not wards of the school. And the thing that I love about this meeting and you people sitting up here is that I get to address all of you, and there's communication between us. And that's not happening at the school board. The communication is halted. The other thing was the cost of the special session or special election. The school district, like I mentioned, has a consolidated debt loan right now that's going to total $512 million from the past 2 decades. I was told it was from like the 2008 era, and then added funds going forward. It was all consolidated into this mega loan. 144 million of that is going to be interest. So I understand where you're coming from about asking about $250,000, but these people are mismanaging our tax dollars by the hundreds of millions. Hundreds of millions. And what are my children's mental health worth? When we have boys going into girls' bathrooms, and I'm not talking about transgender children. I'm talking about boys in boy clothing going into girls' restrooms, and it's happening. What about those girls' safety? What about the male teacher that's in the restroom, and then a female walks in and sees, everything? What about the safety for that teacher? This is so much bigger than masks. Masks are irrelevant at this point. It's everything else, and I just implore all of you to please look beyond what we see in the media and please investigate some of this stuff for yourselves. I would be happy to speak to any of you about my experiences that I've seen.
Thank you, Ms. Delaney.
Thank
Are there
you.
any questions for Ms. Delaney? Thanks again for your
Thank
time.
you.
We appreciate you coming forward. All right, we're at the end of the public comments. Are there any other items that anyone on the board would like to comment on? Only thing I would add, and Bill and Ms. Delaney, as you know, I served in the legislature for a long time, and if we had the time, we always took the time, or even when we didn't like their opinion. I remember there's a school, we had a meeting at the King Center on education, and my wife was worried about my safety. I don't know what else was, but you know, that's what you do as an elected official. You take it because you're and so I hope that if I've not been to these meetings, I don't pretend to I know the answer, but you know, the rule one in Florida politics is, at least, is we're the Sunshine State. And you should be accessible. And it's one of the things I think a lot of us who are in office take pride with. So I hope that, I know there's a lot of emotional things going on right now for obvious reasons, but one of the things that really stands out, and it's a very good election policy, by the way, also, is be accessible and take the slings and arrows, because just like there's people for you, there's people against you, and that's part of the business of being in politics. So hopefully that will start to change as we get out of this difficult time with COVID, et cetera. But it's an interesting time, to say the least, and I really appreciate everyone's patience today. I think we made a lot of ground, and I think with the good work of our staff, Mr. Gugelman, we can make sure all these technical issues get taken care of. So however we choose to vote, it's an informed decision, and it's one that when the voters have the final say, that they'll feel confident that we did our homework in this process. So with no other business, we'll have our Vice Chair, Mr. Moore, move we rise, and we are adjourned.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.